So I think we are online now, and we're going to start. So it's my pleasure to welcome you to this conference on the implementation of the DMA. The pleasure is multiple. First of all, because it's been a long time. We haven't had a conference like this live with people in person. And as somebody said, it's good that the family can get together once again and not just behind screen. Even if I understand that we have close to 500 people who are viewing us online. So this CERRE initiative on DMA implementation, which was carried out throughout 2022, and which is culminating now with the publication of the final report of the end of last year. I think we heard a number of people saying this is a very valuable contribution, but I would say, as far as I'm concerned, that it provides some useful operational conclusions. But I think we have to be honest, it still generates a number of questions. And the first one, and first perhaps conclusion, is that the robustness of both the 2022 DMA implementation report and the papers that report bundles, this has of course greatly benefited from the expertise and the full independence of my great colleagues from the CERRE academic team. And so I'd like to first name them, all of them. 5 of them are present here today. Alexandre Destrel, who's sitting there and who has led the project, the academic director of CERRE, Giorgio Monti, Richard Feasy, Martin Peitz. They're going to be present either in person or through Zoom this afternoon. And also Marc Bourreau, who is also, I haven't mentioned him, he's there. And we have also Sally Broughton-Mikova, Amelia Fletcher, and Jan Kramer, who have been also part of this, I think, dream team. I think the value of what we are doing and what we are presenting today has also been enhanced by the participatory process, which once again has been a feature of the project development. And that has involved interactions between the CERRE academics, the CERRE member firms, whether they are gatekeepers or business users, the CERRE member national regulators, and also the Commission officials in charge who have been present in the project meetings, either in a listening mode or sometimes much more actively, and I'm grateful to them for that. But this being said, the enforcement of this new legislation is very complex, and it will be very complex. And it is so, first, because it relates to firms which are global, which are powerful, which are very innovative, and which are basically very complex organizations per se. So therefore, even if the legislation has been devised with utmost care, and we have co-legislators in the room here, even if it has benefited from thousands of pages of consultations and interactions with gatekeepers, private and business users and regulators, and even if its development has benefited from, in all modesty, the original and relevant recommendation of CERRE already since 2020 when we started. Even with this background, nothing or nearly nothing in the legislation can be self-executing. So at this stage, we still have questions, and many questions, about how to make DMA implementation effective and proportionate. And I think the fact that you are gathered here and that we have so many people viewing online, I think is an illustration of the interest of our initiative. I will make at the end of the conference, normally around 5:45, an important announcement, and when I conclude the conference, so please stay with us until the end of the event. But before that, we've prepared a full program of goodies for you. First, 2 keynote speeches from directly involved senior policymakers, then 3 panels, and then a final keynote from another senior policymaker. So let's start immediately. It's my pleasure to invite the leading MEP in the European Parliament, who has been the rapporteur of the project, my friend Andreas Schwab, to take the floor and to share with us his current views on DMA implementation and on the CERRE 2022 report. Andreas, the floor is yours.
Thank you. Thank you very much, Bruno, for the invitation. I'm very pleased that you are all here. I have to disappoint you a bit because I will not be a goodie for you. I will speak about effective implementation of the DMA. Proportionate is everything in Europe, and therefore this is not of concern for me today. I speak about effective, and I'm very pleased that you take the time to listen on this story again, because the starting point of all this has been in 2014, when the European Parliament in November has been asking in the resolution that has been drafted by the Internal Market Committee, the Commission to come up with legislation. And we are for sure very grateful that after 6 years, the Commission was able to manage to come up with the proposal. And we believe that the proposal was already quite good when it came out, but still the work in the Parliament has improved it a lot. And therefore, I'm very happy here again to repeat what the timeline is, because the law has been decided. It is published in the official journal on the 12th of October. It has entered into force on the 11th of the 1st of November 2022. And it starts to apply in May next year on the 2nd. And then we expect soon also designation decisions. And I'm sure that Alberto will speak about that later, because we know in the Parliament that the decision of the concrete steps is an executive task. And therefore, we will have a very close look on what the Commission will be doing. But we will not create troubles. We would just want that this process is streamlined and is extremely effective. And for sure, in Europe, always we are bound by the law. And the law is always foreseeing proportionality, legality, but in this case, and I think this is most important for the Parliament today, effectiveness. Because what we have been seeing before 2014, when the European Parliament came up with that resolution, was obviously that competition policy was not effective at all in the digital context. So I think it's very important that we take this implementation seriously as a Parliament, always checking with the Commission in the working groups that we have set up on how most effectively legislation can be implemented. And I think we have also been getting aware of a very strong trend in legislation in Europe, that whenever there is a complex matter, Article 114 is the best starting point, as Article 114 allows member states to have their say in a proper manner in the Council, looking for majorities, and therefore keeping the big arguments together and leaving the small arguments aside. So although this was competition policy behind, it has become a regulation of the internal market. And I think the internal market has been in digital getting a very strong tool, which has a worldwide vocation. I have just been again this year in the US, and obviously more and more people have understood that what we do here is for the best of all citizens and for the best of all companies. Maybe not for the best of some shareholders of Gatekeepers, but they can shift their shares to other companies, and therefore, if they are smart, it can also be good for them. And it gives a very strong signal to international markets, especially if the Americans will come in, that we defend competition and we defend open markets, and we do that very effectively. Therefore, the guiding principles have been contestability and fairness. And these principles are very vague. And therefore, Bruno, not only you have questions, I think all of us, we have questions how to translate these principles into practice. And I'm sure that there will be plenty of answers on the same question within the parliament, within the academic community, but also within the commission. And in the end, it's the task of the commission to bring that together. You know, and I don't want to repeat it too much, but I'm asked to do it a bit. You know that the most important points for the EP were not only to strengthen this proposal, but also to make sure that the scope is really reaching out where it may hurt. And we haven't been watching on the companies too much, to be very blunt, because you were mentioning them in your introduction, Bruno. We haven't been looking too much on the companies, because if you look too much on this, you see so much money, you see so much stuff that you may lose a bit the attention. So it has not been a big debate about these companies. And I have to tell you that also the impression I had was that these companies were aware of the fact that they have enough possibilities after to still keep their markets with them, maybe not 100%, but to a large extent. So they were also behaving very seriously, because I'm all the time, and this is a bit of a pity, and I'm very grateful that we don't speak about it today, it's all the time about lobbying. I would say that there was not that much. It was a discussion with colleagues about the best arguments, and I think we have been managing this together quite well. But two key elements have been added for specific reasons of parliamentary attention. And one was the interoperability element, which is for sure a very strong intervention into a market, no doubt. And here, that's maybe the only part where proportionality may play a role, because obviously it's very much linked to one company. But still, we believe that as we have done in the single market between telco companies, where we have also been hurting hard, we have to do that. We had to do that also in digital, and we hope that the Commission can deliver on this. Although there are still not only open questions, but also open elements where we don't know where it will exactly go. Secondly, I would like, apart from the threshold and the strengthening of the cooperation tool with national competition authorities, the data element has been also playing a key role, especially for a certain number of colleagues. Although we know that data is not only the new oil, as the economist has said, but also like sunshine in the digital economy, we have to make sure that there is enough, and therefore the personal data and targeted advertising are elements where data is needed, but where we have to make sure that basic principles of the European Union and fundamental freedoms are kept. And I think the compromise, especially with the DSA, that we were able to strike is good. So I don't want to go much deeper on this. I think it's very good that we have been strengthening also the timetable. I know that Alberto is not liking that much, because it creates a pressure, not only going for the next step, but also for the step after. But we have been waiting for too long. And I think there was a very strong pressure, not also with colleagues, but also in the market, this to happen. And I'm very confident that we will see also the outcome of the DMA sooner than with the first designations, because companies have understood that there is something to be done. And we see already now partly that companies do adapt to it. I think there is one key principle that we have to understand, and that's that the member states will remain important. They will have to abide by the rules themselves, but they will also be needed to support the European Commission. And therefore, this cooperation element is very important. And we see, and I won't mention any company, but we see that to a certain extent, companies are already integrating elements of the DMA into their business policy. And I think this is not only intelligent, but also smart, and it will make it easier for the Commission to deal with it. Now, the commission or the law that has now to be implemented by the commission, and I think this is a very important point, is clear. But fairness and contestability are not enshrined in details. You cannot, as a lawmaker, say what enforceability in that area means, because it's always a balance that has to be found between different businesses, between different business concerns, between different interests. And therefore, there is a certain level of regulatory exchange needed, which should not mean that there can be a negotiation about the application of the law, but about the fact how the best balance can be found on a specific point to achieve fairness and to achieve contestability. And therefore, and this is the main reason, I think you want to mention these questions today here in CERRE. We as a parliament want to follow the process because we believe it's of utmost interest not only to the businesses, but also to citizens, to those that use these services, and we are growingly using these services altogether. And therefore, we want to be part of it, but we will not make the life of the Commission more difficult. We want to help to implement it in the right manner. And therefore, we are looking already on 6th of February for the second time with that working group that we have been setting up on how interoperability can be better managed and how we can achieve it. And we will also speak about other elements that will be important at the beginning of the implementation. But as this implementation is done with Alberto, I will stop here. I'm very grateful for your interest and your attention, and I'm looking forward to the next speech. Thank you so much.
Thank you. Thank you. Thank you very much. I don't know if I'm on. Thank you very much, Andreas. We have the time for a couple of questions from the room or online. If viewers want to put questions, can I invite them to do so using the Q&A device on the Zoom panel below, and to make sure that they put not only their name but also the organizations to which they are affiliated. I'll first see if there is a question here in the room for the MEP. Who has a question? You have a question, Alexandre Destrel.
No, but I mean,
what is your organization?
CERRE. Thank you very much, Andreas, for this speech. If you can explain a little bit further, how do you see the role in the parliament so you say there is this meeting on the 6th of February, but more until the end of this commission, and maybe also for the next commission and the next parliament, how do you see the role of the parliament in monitoring? Because, you know, this is a very new function for the commission, you know, to become a regulatory authority. And so maybe it implies also a new role for the parliament. I don't know.
Well, I mean, we have some experience with competition policy where the Commission has the same function, but we have to admit that in that area, there were always very confidential informations that have to be shared, that the Commission can ex officio gather, and these informations should not be part of the public debate. I hope always that the Commission is sharing all them with me. But we won't be able to share it all the time in such committees. It is important to have a feeling about fairness and about contestability. And I have no doubt that the Commission will manage very well that balance can be found. But I think it would be a bit dangerous to say that this can be discussed in conferences in all detail, because some practices are a business, and we should respect it as well. But that doesn't mean that we don't go for an effective enforcement and that proportionality comes only at the very end.
Okay. Anything else? Then we will leave. There was no. Okay, so we'll leave it here. Thank you very much, Andreas. I think you can still stay a few minutes. So it's my pleasure to introduce Alberto Bachiega. Alberto Bachiega is director at DG Com, and he will be, and he is already in charge of the directorate, which will be looking at the implementation of the DMA. And we are grateful to hear his views at this stage on the implementation process, which is starting now. Alberto, please. And thank you very much for joining.
And good afternoon. So I would like, first of all, to thank CERRE for organizing this conference, the very title raises a very important question, is how to implement the DMA. As you can imagine, we are spending quite a bit of time in the Commission trying to answer that very question. The one thing we are absolutely convinced of is that is not a matter for a closed shop type of discussion, but is a question that requires an open debate. We do not want the DMA implementation to turn into a bilateral discussion between the Commission and the gatekeepers. And that's one reason why we are organizing a technical workshop exactly on that point, on how to practically envisage compliance with the DMA, and we are doing it by topic. We had the first one in December, and more will come. And that is why for us it's very welcome to receive such a wealth of input from academia, from think tanks, and from conferences like today's on the implementation of the DMA. So for my introductory remarks, I wanted to touch upon three themes. The first is a small update on our preparations for the implementation of the DMA. The second, how we see the interactions with gatekeepers in this process. And the third, a couple of considerations on the recommendation paper that Alexandra coordinated, and that will be the topic of the discussion today. Must confess, I picked up two easy ones, and I leave the difficult discussions for the panels afterwards. But let me start with a quick update on the state of play with implementation work. Andreas already mentioned the main timeline for the implementation. Looking forward, applicability is the 2nd of May. That triggers, as everyone knows, 2 months for gatekeepers to notify their core platform services. That brings us to the beginning of July, and that triggers another deadline of 45 working days for the Commission to adopt the first wave of designation decisions, which means quite a busy summer for us, because the deadline is early September for that. And 6 months from the designation decision, compliance kicks in. So that from first half of September brings us to first half of March next year, so spring next year, let's say. And that's when the impact of the DMA on European businesses and users and citizens should become apparent. At least that is our goal. That all this is in the future, but the implementation of the DMA for us has started quite some time ago. Basically, from the moment there was a stable compromise text by the co-legislators, we started discussing with interested stakeholders, gatekeepers, but also businesses and other stakeholders that are meant to benefit from the DMA. And we are very pleased to see first that many stakeholders do want to engage, but also that many see the DMA as a positive development to increase fairness and contestability of large digital platforms. And also we are happy to see the stakeholders actively engage and put forward their needs and potential solutions, not only potential gatekeepers, but the broader European stakeholder community. So for us, these two groups, we try to put them together, the potential gatekeepers and those who should benefit from the DMA in the workshop I just mentioned, in the ones we will organize. This formula has been a success in our view, and also showed that the dialogue between market participants is paramount importance to design the right changes to the current business models of the gatekeepers. Turning to procedures very, very briefly, as you know, or you probably know, we have just closed the consultation period on Monday, actually, on the implementing regulation. And the implementing regulation basically is the rule book that will underpin the implementation of the DMA. So the implementing regulation will set out the practical rules to interact with the gatekeepers and market participants, leveraging our current experience and best practices to guarantee a lean and efficient procedure and to ensure the rights of companies to be heard and to ensure a proper due process. Consultation closed 2 days ago. I have no news about that. We are analyzing the feedback we received, and our goal, of course, is to have an implementing regulation in force in good time before the DMA kicks in May. Finally, on the organizational point of view, as you know, the DMA is not only new because it empowers the Commission as a regulator, but also because it empowers two departments within the Commission to enforce these instruments. And the implementation of the DMA will be a joint effort between DG Competition and DG Connect. This model has been used throughout the life for the gestation of the DMA, for the preparation of the Commission proposal during the legislative process, and also with all the dialogues we've had with gatekeepers from last spring to today. And it will continue to be that. In fact, in my view, this is very much internal Commission cooking, whether there is Comp and Connect. It's the important thing, I think, to the public is that it will be clear that for the future, companies will have one single entry point to discuss the DMA, will have one interlocutor, will have a coherent dialogue and a single decision. And that is why the way we are organizing the implementation of the DMA is an integrated structure, is joint teams, and the single data and document management system. And I think we can guarantee it will continue to be that way. On the competition side, the DMA will be dealt with in a newly created directorate called Digital Platforms. That will see the light of the day next Monday, actually. But it's basically not a lot will change there either, because there now all the same is being done under the directorate dealing with IT, telecoms, and media. And on the Connect side, there is a sister digital platform directorate, which will enforce together with DGCOM the DMA, but will have additional enforcement powers for the Digital Services Act. Now I would like to turn on the way we envisage the process with gatekeepers. We are conscious that the DMA requires significant changes in the system processes and to some extent business models of some large digital platforms. And that's something we are often reminded of. And we are also reminded of the time and resources implications that these changes will require to these companies. And in the light of this, it is important that companies concerned by the DMAs, and in particular potential gatekeepers, use wisely the time available until designation decisions, and even more importantly, the time they have available until compliance kicks in a little bit more than a year. We are happy to see that several concerned companies are already actively preparing and engaging with us. I can only stress that all concerned companies should follow this constructive approach. But in this context, there is one aspect that we emphasize time and again, is gatekeepers who bear the responsibility to comply with the DMA within the given deadlines. This means in the initial phase that it is the undertaking offering core platform services listed in the regulation is for the companies the obligation to self-assess whether they meet the quantitative thresholds in the DMA. If they meet the criteria, it is up to them to notify the core platform services that are relevant. Within the implementing regulation, there is a notification form that should aid the company in this process and actually sets out what type of information we are seeking in these notifications. And equally, the ongoing pre-notification discussions, if we can call them like that, have the goal to help undertakings in their self-assessment as to whether they should notify one or more core platform services. But also equally, potential gatekeepers should not wait until their formal designation to start thinking about compliance solutions for their services. Again, the technical workshops are meant to provide some input, some ideas, also to explicit the needs of the stakeholders on how what compliance could look like. I think one of the big takeaways from the one we held in December on self-preferencing is that there is not a single solution. There is not a solution that fits all, even if we look at the specific obligations, and that the needs of stakeholders are quite diverse. So it's important for all stakeholders, but for gatekeepers in particular, to understand really what the expectations from the markets are, because the gatekeepers will also have an obligation of result. It's not only a formal obligation, but they will have to deliver the fairness and the contestability improvements Andreas was mentioning. And of course, today's conference is another occasion that is as much important to frame the issues and to seek practical solutions as much as possible. But the responsibility ultimately rests with gatekeepers. The DMA equips the Commission with effective powers and tools to monitor compliance and to sanction non-compliance. A consequence of this is that gatekeepers cannot hide behind issues relating to the clarifications of the legal texts. They have to propose solutions that allow its implementation. This is not to say that we are not open to discussing questions and issues. We have been doing that for several months, and we will continue to do that. However, the discussion must start from a proposal of a compliance model and cover practical implementation issues. It cannot be the other way around, focusing on theoretical implementation issues before a compliance model is presented. And now to conclude, just 2 points on the very interesting recommendation paper I wanted to touch upon. The first is on the recommendation to use the same evidentiary standard in market investigations that follow a sufficiently substantiated rebuttal request and in market investigations for qualitative designation. So basically, as you know, we have a construction whereby we have quantitative criteria. There is a possibility to ask for a rebuttal. There is an entry threshold of sufficiently substantiated rebuttal request. If it is sufficiently substantiated, we will investigate whether the rebuttal should be granted or not, on the one hand. On the other hand, we have the quantitative thresholds that are not met. And then we have the possibility to see whether gatekeepers still have the characteristic of gatekeepers as set out in the DMA, even though they don't meet the thresholds. So these are two separate investigations. And I have to say, I don't agree with the recommendation in the paper that we should use the same standard of evidence between these two types of investigations. In my view, the DMA text is very clear in setting out an asymmetric evidentiary standard and scope of investigation in the two instances. The rebuttal request, which is in Article 3.5 and further explained in Recital 23, is meant to be made in exceptional circumstances only. And this is the case, as I said, when the quantitative thresholds manifestly fail as proxies for the designation criteria that are in the DMA. Recital 23 explicitly states that the Commission should take into account in its assessment only those elements which directly relate to the quantitative criteria. Conversely, the framework for qualitative designation is quite different. Is a different paragraph, is Article 3.8, and this article gives 7 sets of elements that need to inform the Commission assessment. Of these 7, the first 2 look a bit like the quantitative criteria: turnover, market cap, a number of business users, and end users. But the other 5 go significantly further in requiring the Commission to assess the core platform services. And they include, for example, network effects, data-driven advantages, scale and scope effects, user lock-in, corporate structure, and vertical integration of the potential gatekeeper. The accompanying recital, the 28, is equally rich in setting out the elements that we have to use when we do a qualitative type of designation. So given the way the text has been designed by the co-legislators, to me, it seems quite clear that it's not the same standard that we should apply. And besides, if it were fully symmetric, basically the quantitative criteria would lose most of their value, because if the quantitative criteria apply and then we receive a rebuttal request, and then we have to do the same market investigation as we have to do when we use the qualitative criteria, basically we add a passage, but we end up in the same space. So in the past few months, we've been clear in our feedback to potential gatekeepers regarding the exceptionality of the rebuttal route and what our assessment will cover. So if there is a message we like to pass today, is that we think it would be unproductive for potential gatekeepers to use extensively this option in view of its exceptional character. This is not to mean that is there to be used, but is there to be used really as an exceptional possibility when it is clear that the quantitative criteria are met, let's say, by mistake. Now, on the second point I wanted to mention regarding the recommendations in the paper is one on which I couldn't agree more, actually. And it's regarding the central role of compliance reports by gatekeepers. I fully agree on the importance of these compliance reports. So compliance reports, the first will be when compliance kicks in, and then they have an annual timeline thereafter. And they will have a crucial role in the monitoring effort, not only of the Commission, but those of interested stakeholders who should have access to a clear and comprehensive summary, I think I'm quoting a recital here, that allows them to assess compliance and ultimately can assist the Commission in its enforcement effort. There are very useful practical suggestions in the paper on how to structure the report and the summary, and these are suggestions we will certainly actively reflect upon in the coming months. So I'm sure that today's discussion will cover many more issues and provide everyone interested in the DMA with plenty of food for thought and inspiration for practical and efficient solutions. The DMA offers a great opportunity to foster innovation and choice, fairness and contestability in the most important digital markets. Like any other law, the DMA will prove successful only if it will be implemented effectively and fairly. The European Commission is determined to make it a success, but we know we cannot do it if we close ourselves in an ivory tower or in a Madhu tower, for that matter. That is why events like today are so important for us and for all stakeholders to make the most of the opportunity that the DMA offers. So thank you very much for your attention, and I'm really looking forward to the debate.
Thank you. Thank you. Thank you very much, Alberto, for your kind words, your informative work, also for your constructive criticism about things. There are a number of questions here. I have at least two. Are there questions in the room? Can you please give the mic to the gentleman there? And sir, can you please give your name and your
Yes.
organization.
Yes, my name is Antonio Manganelli from the University of Rome, LUMSA. And I would like to ask you about the effective implementation of DMA. I think one of the more important thing is the institutional setting. Of course, to preserve in a way the centralization of the enforcement of the DMA, which makes very much sense to me. So in a way, reduce the externalities coming from a decentralized, for example, enforcement of competition law by national competition authorities on the same behaviors or similar behaviors by gatekeepers. So my question is if, since of course, competition law and the DMA are two different set of rules which complement each other, as the regulation said, but still the Commission can centralize the competition law enforcement, applying, for example, Article 11.6 of the Regulation 1/2003. So my question is, if there is, since the enforcement of the two pieces of legislation within the Commission is the same directorate, there is any plan or any way intention to have a more use of this in Article 1.11.6, so initiate the proceeding and relieving NCAs, or any way to exert some moral suasion on NCAs in order to preserve the centralization, which, according to me, is very much part of the effectiveness of the enforcement.
There are two aspects here. There is antitrust enforcement, for which there is a relationship with the NCA that has been in place, and there is how the DMA interacts with the system that is in place. The DMA is very clear in stating that the Commission is the sole enforcer. It also has provisions to preserve the capability of national authorities to implement Article 101 or 102 or the corresponding, and also possibly to implement other legislation that doesn't have the same goals of the DMA, but that may target the same companies, the same products, and so on. So I think the institutional setting is very clear. The way the relationship has worked with antitrust has been very good. That I will, of course, I said, but I think effectively it's been good. The question whether we need to, take over cases explicitly about moral suasion is always the same debate that you have between colleagues, and typically, we solve 95% of the issues discussing, and we find an efficient solution. And then the other 5%, maybe we hadn't seen it coming. The aspect that require a case to be dealt centrally in Brussels instead of more diffusely in the national by the national competition authorities, but certainly the goal is to leverage on our common resources and not to double the work. And we will do exactly the same in the implementation of the DMA. It's getting more of a matrix. It's getting a little bit more complicated, but it's complication, is not confusion. And that's where, good discussion, good debate, and the spirit of collaboration can bring us very, very far. On top of that, the DMA itself, and Andreas mentioned, gives a very important role to national authorities and to national competition authorities in monitoring the implementation of the DMA, possibly in helping us initiate cases, and also in investigating together certain aspects if that is possible. So I think we have plenty of opportunities to leverage the resources, and we will make the most of it. I think that the relationship of resources between the enforcers and the gatekeepers is already asymmetric enough that on our side, we should use it in the best way possible.
Okay, I thank you. I still have a few questions, and I have questions online also. I think there's a gentleman over there. Can you please give your name, please?
Yes, my name is Tono Gil from MLEX. I actually wanted to follow up on the previous question to see if Alberto could simplify that with a case we've seen today, actually, in Germany with the 19A section. It involves Google statement of objection on processing data that is pretty similar to one of the obligations in the DMA. And I wanted to know, because the Bundeskartellamt has said that it has been in contact with the Commission, coordinating, and to see if you could give us some insight on, for example, in this case, how have you been coordinating with the Bundeskartellamt? And what is the overlap in this case when, for example, the Bundeskartellamt has said that this case exceeds the obligation of the DMA or the scope of the DMA?
We will take another set of 2 questions which are online, and then I'll ask you to wrap up.
I'm afraid, very brief answer. I think the DMA has a different legal basis than competition enforcement, and there is a lot of news. Something that will not change with the DMA is that we don't comment on ongoing cases.
Okay, thank you. 2 questions here. I have a question from Leo Rees, or Race, who asks, can you say anything about what DMA obligations you're considering to be the subject of the next technical workshops? What is the agenda of the next workshops?
It's an excellent question. We are very keen on communicating on this, but it's not today that we can communicate. We will do it soon. We want to do it relatively soon, but we want to present a product that is, something that is presentable.
Okay, thank you.
Sorry for that.
All right, so to be followed. And the final one is from Pedro Uribe from ESIC Spain, who asked basically, are you tracking the advances that the gatekeepers are making in their process to prepare and to implement the DMA? Are you following that? And can you say something about that?
Well, of course, we are following. I think there are I think for the very, very large plans, these are plans that the gatekeepers have. So it's not market monitoring of changes that are already taking place in the markets. Gatekeepers tell us, and I think it makes a lot of sense, that it takes a lot of engineering and a lot of resources to do the necessary changes, and that it will take time. So the changes are not there yet. For that reason, and for maybe also for commercial reasons, we don't really expect gatekeepers to start complying with most of the obligations and provision of the DMA early, if they can, if they have a deadline. What we really expect is them to comply by the deadline. So we are tracking it, but that's mostly part of the dialogue we are having with the gatekeepers that come with possible models, with options, and how they intend to comply, and with questions, and that's the dialogue we're having.
You talked about resources. Let me ask you a question about where do you stand in securing the necessary expert resources in the Commission? Where are they going to be located? We hear that they're going to be in the JRC, the Joint Research Center. Are you going to have them in Connect, in COMP? And where are you, and how optimistic are you that you can, in a market which is very tight for expert resources of the kind that are needed, to find the right one in due time?
So I can say more for COMP, because that's something I know. We know what resources we will have available, and we've been knowing now for quite some time. We had the opportunity to recruit. We are recruiting. People are coming in. We are quite happy with what we are having so far. I can tell you that the new directorate will have 40 people in COMP. I know that colleagues in Connect are working on a similar basis. The JRC is a service of the Commission where there is a lot of technical and scientific expertise, so it only makes sense that we use that expertise as well. So I think what I can say now is that what the Commission has put in place is a clear roadmap in terms of resources that will allow us to be ready when we need to be ready for the implementation of the DMA.
Okay, thank you. I will take a very last question, that gentleman there at this stage, because we need to carry on. There are going to be plenty of other opportunities for questions. Please, sir, can you give your name? And
Javier Huerta from Calen International. If I understand it well, the possibility to empower NCAs to play a role in enforcement of the DMA. It is a sort of prerogative for member states, so they are not obliged them to do so. And I guess that, for example, the German NCA will be interested in playing a role there, but I have also heard other NCAs manifesting no interest or in playing a role there. So I was wondering if you had already gathered data on which member states plan to empower their national competition authorities and what others do not plan to.
But we are certainly monitoring it also because we talk to the NCA constantly. It's not something for me to comment here. Is more a question to each NCA. There is the need to for national legislations to empower the NCAs in order to be able to perform center powers under the DMA. Of course, every member state is sovereign, and they will decide what the priorities are in every country and from every competition authority. From our point of view, we are delighted to work with them. We will do more, but of course, this is a national competence on which the Commission doesn't really have much to say.
Thank you. Thank you very much. I think this will be the final word for this first session. I'd like to thank very, very much Andrea Schwab, Alberto Basiega. Thank you very much, and we look forward to seeing you again. I'm sure there will be opportunities. Thank you. So the panel is Frank Key, Senior Director, Legal Counsel, Qualcomm Online. Hi, Frank, we see you. Carol Maske, Senior Attorney, Microsoft. Hello, Carol. Carolina Lorenzon, Director, International Affairs, MFE, not to confuse, sorry? Media for Europe, formerly Mediaset. You still Mediaset, okay. Michael Koenig, Advisor for Digital Market in DG Connect at my far left. And the authors of this, of the papers which are going to be discussed are Richard Feasey, who is online. Hi, Richard. Do we hear you? Okay, and hello, Richard, and also Giorgio Monti, CERRE Research Fellow, and Richard Feasey, a Senior Advisor at CERRE. And the moderation is going to be done by Alexandre de Strel. You have the floor, Alex.
Okay, thank you very much, and thank you to this panelists. So what we agree is that first, the recommendation will be presented by the main author. So Richard will present the one on designation, and then Giorgio will present the one on procedures for 5 minutes each. And then we will have a reaction of our panelists. Starting with Carolina, then Carol, then Frank, and we will finish with Michael from the Commission. So Richard, you can go on.
Thanks, Alex. So we have two recommendations or 2 points to make, I think, in relation to designation, one of which Alberto referred to earlier, and I'll come on into a minute. The first is relates really to a question about what is the intended scope of the designation of a gatekeeper. And perhaps the best way to illustrate that is to consider a firm that meets the turnover and market capitalization thresholds in the DMA, and then provides a number of cloud services or a number of different advertising services, which are consumed by active users. And some of those services, say service A, meets the quantitative thresholds that are in the DMA in terms of the number of active users, but cloud service B does not, and cloud service C may or may not. So these are distinct commercial services, each with distinct groups of active users consuming them, some of whom may overlap, so they may consume several sets of different services from the same platform. And the question really is, and the thing that we think is important is what is designated as what is the gatekeeper designated in relation to? And our recommendation is, in the example I've just given of a cloud service where there is a commercial service where the number of users meets the quantitative thresholds, but that same provider also offers a number of other cloud services that don't meet it. That firm is a gatekeeper only in relation to that specific cloud service A, because we think that the intent of the DMA is to identify market power in relation to the provision of particular services, not the market position of a firm generically, if you like, in relation to a category of services, or just in relation to the size of the firm. So our proposal and our recommendation is that gatekeepers are designated in relation to specifically identifiable commercial services, and not in relation either to the general category of core platform services, or just in relation to the firm itself being a gatekeeper, sort of independently of the nature of the services themselves. And this is, I mean, it may sound like a semantic point, but it has some legal consequences, but it also has practical consequences for how firms complete, or it may well do, and how they complete the form GD that the Commission is now proposing as in the implementing regulation. You know, does the firm submit one 50-page form in relation to all of the commercial services that it offers? Does it do it only, does it do a separate form for each of the cloud services that it offers? Or does it do a separate form for each of the specific cloud services that it offers? So one for service A, one for service B, and so on. And obviously, if firms are to be sort of fairly treated by the Commission and to have an equal opportunity to make their representations, a common approach to what is required and what is the scope of the activities that need to be covered in each form is obviously quite important, and that's not very clear, we think, at the moment. The second point, or the other point that I just want to refer to, Alberto raised, which is this question of, I mean, the way you could think about it is the risk of false positives in the designation process versus the risk of false negatives. And there are processes in place to allow gatekeepers or potential gatekeepers or companies that might otherwise be gatekeepers in terms of the quantitative criteria to argue why that would be a false positive and they shouldn't be. And there are provisions for the Commission to identify companies that don't meet the criteria, but it considers are nonetheless gatekeepers. So the risk, to avoid the risk of false negatives. And we say in the paper, and you've heard Alberto's views, that the Commission should think about those as being essentially symmetric tests with symmetric standards. Alberto was concerned about the risk of firms being able to argue, and the evidence required to argue that they shouldn't be designated. I think the motivation for us is more in relation to the chilling effect. If the standards for the Commission to be able to prove that firms that don't meet the quantitative thresholds are gatekeepers, that might create quite a high degree of regulatory uncertainty in the market amongst firms that otherwise might expect or be confident that they won't be subject to the regulation. So that's our recommendation on that, is that we should think about that symmetrically. Those are our recommendations on designation.
Thank you. Thank you, Richard. Now, maybe let's go to the process and procedures. Giorgio.
Thank you very much. I'm going to focus on 4 elements of the paper on processes and procedure. The first is that the DMA creates a structure for a cultural change in the regulation of gatekeepers from an enforcement model, which looks like antitrust, to a supervisory model. There are several elements of the supervisory model that are inherent in the DMA, which I think are worth exploring and discussing in terms of how they may be fleshed out. The first is the compliance report, which has already been discussed by the keynote speakers. So the gatekeeper has an obligation through this report to demonstrate effective compliance. And it's not clear what that actually means. So it'll be a process of exploring how this demonstration can be carried out. And I think there's a question of processes, how the gatekeeper designs and thinks about compliance and with whom the gatekeeper consults. So should the gatekeeper, for example, consult third parties in order to identify which of various potential methods of compliance is most suitable? And then there are questions of outcome. So how far does the compliance report express expected outcomes from this mechanism of compliance, so that through doing this, the gatekeeper foresees that the outcome would be that. So I think there's lots to explore on how the compliance report is going to be prepared and designed. And of course, it's important also that compliance evolves over time. So the fact that the report has to be revised annually has to account for the fact that markets may change, and therefore the way in which one complies changes across time. It's important, thirdly, that the compliance report allows business users and the beneficiaries of the DMA to make active use of these compliance mechanisms so that they understand exactly what it is or how it is that they can engage with the gatekeeper and how can they gain access through the market through the gatekeeper from the compliance report. So the public version of the report is also quite significant because it has to allow the third party to be able to benefit from the compliance efforts. Related to that is the provision for regulatory dialogue and the provisions for specification that the Commission has. So whilst in the keynote speaker suggested that perhaps there is a more composite discussion between the Commission, among the Commission, gatekeepers and third parties, there's also within the DMA the provision for bilateral discussions. And I think it'll be interesting to see how these develop. What we suggest in the paper is that the specification decision is well set out, but the regulatory dialogue one is left a little bit more open-ended. And the recommendation we make there is that we make sure that for both of these, the third parties are involved in allowing the Commission to also hear them, rather than just this being a bilateral dialogue between the two. The second point we make in the recommendation report is that it creates the opportunity for moving from an enforcement structure which is designed to deter to one which is more designed for along the models of responsive regulation. So we draw on the literature on responsive regulation that's been around for about 20 years and suggest that a model of persuasion through facilitating the design of effective compliance is to be preferred to a model of enforcement which is based on fines. Now, I should preface that the DMA does not create a hierarchy of enforcement. The Commission can start enforcing wherever it wants. It doesn't have to start at the base of encouraging compliance. It can go straight to fines. But there is academic literature which suggests that if you persuade, that may be less expensive and more effective than if you immediately start with a deterrent effort. The third point we make in the report is that we think the DMA should encourage participation by third parties, and we point out what within the DMA structure are the options for third parties, and alternative options, additional options are suggested in the paper. And the last point I wanted to make was the high-level group in the DMA. I think this has the potential for achieving a lot of tasks, but perhaps the most important one is that now that many gatekeepers are subject to multiple digital laws, one of the things that high-level group could work out is how to integrate and make sure that compliance across all digital regulation is rendered more coherent for each gatekeeper, and therefore facilitating compliance across the board. Thanks.
Thank you very much, Giorgio. So now let's go to the panelists. So what we have asked them is a bit like Alberto did in his keynote, at the end of his keynote. One thing they like in the two reports that they have been presented, and one thing they like less. For 3 minutes, I must also recall the audience here and everywhere that everything is on the website. So all those recommendations and the issue paper which support them now are on the website in a consolidated manner, and because we have delivered them during the course of December in pieces, but we understand that sometimes it's not easy to find information, and so now since today you can find a consolidated version of everything on our website. So I will start with you, Carolina. One thing you like less in the thing we have just heard today. Thank you.
Thank you very much, Alexander, and maybe I should just take what Alberto Bacchiega said. I fully subscribe to his remarks, and namely on the asymmetric evidential standards between Article 3.5 and 3.8. We also agree that exceptionality rebuttal should be an exception, whereas if in Article 3.8, as provided in Article 3.8, if the quantitative criteria are not met, there are a number of qualitative criteria, and namely, as Alberto underlined, especially network effects and data-driven advantages and business users and end users lock-in that should be taken into consideration. In terms of reacting to Giorgio's presentation, but also Richard's on the process and institutional design, I must say that to us, it seems this recent notion of responsive enforcement seems quite awkward, because when we broke up the monopoly of state-controlled media, we simply had to abide to ex-ante antitrust rules right away, and sector-specific rules and fines were imposed. So we're just afraid that this might be just after over 10 years in which the TV market has been up for grabs, we will end up losing precious time. So we'll stop there. And then maybe, thank you.
Thank you very much. Now let's go to Carol from Microsoft.
Yeah, thank you very much. Thank you. Thank you very much for having me. Thank you very much for organizing this discussion. I think what I like the most actually is these kind of family events of discussing the DMA. I think this has evolved over time from a process that has been very controversial, and now is a much more academic and much mature discussion of the arguments for the interpretation. And I think it feels for a lot of us like back to school or back to university in learning a lot about new concepts. And I would like to thank CERRE for enabling this process, of being one of the main players in organizing this discussion, which has been very helpful. And what I like between the paper and Alexandre, it's probably, or it's not because of Alexandre, you organizing a lot of this, but the more conceptual paper on the compass for the DMA, because I think that's something where a lot of work is needed, where ultimately, obviously, the courts have a say in interpreting the law, but where, as Andreas Schwab put it at the outset, you know, a lot was left for interpretation, what contestability and fairness means. The compass is the first step of trying to address that. More steps need to be taken where this is going, but to me, it's the most interesting question. And again, thanks for taking up that topic for the discussion. I'm struggling a little bit with the evidentiary standard and the topic Alberto has picked up, and you took sides. I'm leaning towards Alberto that there is a different standard, obviously, but I'm looking at this shortcut of the threshold a little bit differently. These thresholds are a tool to easily identify gatekeepers. But I think they are not supposed to make companies that are, or services that are obviously not gatekeepers, make them gatekeepers more easily. So I think it's a little bit a middle ground, because what's suggested in by Richard in his paper of you know, the symmetrical standard the standard might be different, but the tool of the thresholds is to facilitate enforcement and not get to a lengthy discussion about who's a gatekeeper or not. If you meet the thresholds and it's clear you are a gatekeeper, there should be no room for further arguments. But when it comes to this question, and it's obvious that no one in the legislative process and later on would consider certain services to fall in that category, that there should be room for an exemption because the law provides for an exemption. It will be exceptional. I totally agree on that. And there will be the challenge to find, common standards where how to identify those and what is obvious and what's not obvious. But ultimately, the criteria that define large gatekeeping platforms should be the guidance for, making that decision. So it's a little bit, kind of a middle ground. I think it's still open for further discussion, and I see people have different opinions on that, and it's look very much forward to continuing that discussion.
Okay, thank you very much. I think we will come back on this designation issue and this symmetry or asymmetry. It's true that the legal text is a bit asymmetric, but then the question is what it leads in terms of type 1 and type 2 error that Richard was mentioning. Frank from Qualcomm.
Yes,
But
thank you, Alexander. And I have to disappoint you that I only have one comment, which is a positive one about your report. And I want to speak from my perspective generally as an in-house practitioner. My main comment is I want to echo Alberto and Giorgio's comments about the centrality of compliance reports and agree with the recommendations that the EC should think about setting forth in more detail its expectations on what the compliance report should contain and what might be best practices. I realize compliance reports are not always the most provocative, provoking topic, but this is one that is extremely important to get correct because it is ultimately what is required at the end of the process. And because it's required at the end, it bears tremendously on what happens at the beginning of the process. This goes to obviously the first principle of effectiveness of the DMA. One of the questions in the report that struck me as particularly important is the report says, or the recommendation says the report should have the gatekeepers lay out various compliance options that were considered and explain one was chosen over another or other options. Because this will have, the gatekeeper should explain because this option that we chose will have so-and-so practical impact on user choice or access for relevant third parties. Giorgio mentioned earlier about a persuasion versus deterrent model. I think this is persuasion, but kind of in the other direction, a way for gatekeepers to persuade the commission that the option chosen here, the remedy chosen, is going to comply with the DMA and have an actual impact on choice. This will help the commission, I think, not only assess effectiveness, but also proportionality, right? Because there may be equally effective options, but the gatekeeper can defend its chosen choice because it says, hey, this one is equally effective or at least sufficiently effective as the other choices that have not, I haven't selected here because other ones are not proportional to what's required under the DMA. The added certainty and predictability here has no tension with the key principles of effectiveness and proportionality. I think they actually further them. And that's my perspective. Alexander.
Okay, thanks a lot. And then we finish with you, Michael, on what you have heard so far and what do you think about all of that?
Yeah, thank you very much. I mean, I could, of course, dwell on the same points and have it easy on both the symmetrical issue and the compliance reports, which are, I think, as it turns out, really central points in these two stages, let's say, in the designation stage on the one hand and the stage of compliance on the other. But I thought I will add a few, two other aspects that I picked up as I liked and I want to nuance from the report, and then maybe we can dwell on the others again in the conclusions and in the Q&A session. Maybe on the one that I want to nuance is not completely new is also the question of this responsive enforcement. I think where and we very much agree, is that this is a different nature of supervision. This is an ongoing supervision. This is not case by case. This is a more ongoing relationship with the companies in scope. But having said that, we are obviously open for a dialogue, for discussions, for giving guidance, for informal exchanges. But there will also come the hard moments where we will have to agree to disagree. And then I think it is a question on what are the most effective enforcement tools that the Commission will be ready to deploy. So obviously, the use of any of these tools is subject to the proportionality requirement. But it's also clear that in the legislative process, there was a clear tendency to strengthen these enforcement tools, not to establish a hierarchy of the different means. And we have it, for example, explicitly in the provision on the specification decision, which says that nothing in this specification provisions prevent the Commission from going straight to enforcement and more fines types of measures. And I would see the sort of triage, if you want, in the question on whether there is a good faith attempt in compliance, which may need some fine-tuning because it's not fully effective, or whether we are faced with more blatant non-compliance where a dialogue or further discussions means relatively fruitless. So I think these options have been included in the provisions for good reasons, because there's another objective behind the DMA, overarching, which is also speed, to get to solutions and not to allow too protracted means in the process before real change can be enacted. So this is the part where I would also nuance a little bit on what is in the report. The other one where I can only fully agree is what you then label as the participatory enforcement and the key role of third parties. I think it's obvious that the DMA and the DMA obligations are designed for specific beneficiaries. They are meant to have an impact and to make a difference on the ground. And therefore, it's obvious that those that are meant to benefit from those measures have to have a say on the implementation and whether the implementation is effective or not. So that has been reflected again in the legislative process at key stages, formal stages in the procedure. And you've seen that we as a Commission expanded this, if you want, to the informal now pre-application phase with our workshops. And we very much want to further this concept. Now, what we, of course, will have to also reconcile is, again, with the other principle of speed. So there is again, a trade-off between very broad consultation, bringing third parties in, but at one point, we also have to conclude and get two results. And that will also mean that third parties will have to be reactive, very quickly reactive, to be able to bring in this valuable input that we all need. What I particularly also like is your recommendation, and that brings us back to the compliance report, the involvement of third parties also there, that it is a recommendation and an invitation to gatekeepers to already include this when they develop their compliance solutions. And I definitely would think that those reports will be more plausible, more robust when third-party feedback is included. And then they may also have a role, and I think this is a very interesting avenue, which I'd also like to highlight, in developing what I would call like the key effectiveness indicators that you refer to in the compliance reports. Also here, I think the input of third parties is necessary to shape those well, because those indicators and the DMA is not about individual companies, it's about opportunities and whether they function, and this, I think, third parties can inform. Thank you.
Thanks a lot for those very comprehensive comments. So now let's open the floor for discussion. So you can ask question in the room, or also for the people who are online, you can ask a question through the Q&A function of the Zoom application. So I don't know if some of you have some question on this designation process and or on the general process that Giorgio mentioned and that has been commented by some. I have some otherwise, but just I want to give the priority to each of you. No, I mean, I have a question maybe for you, Michael, but everyone can comment. But you know, I was intrigued by what Alberto said before in his keynote about the fact that there is no one size fits all. There is also a lot of, and if I understood correctly, but you're still in the room, so maybe you correct me, but that the business user have different needs, and I think it was shown very well during the workshop you organized on self-preferencing. So there is a diversity of need, there is maybe a diversity of solution, and on the other hand, it's the responsibility of the gatekeeper to, as you say, and that's how the legal framework has been shaped, to come with a solution and then discuss it with the commission, the third party, and then the commission will decide whether it's compliant or not. No, and as you say, Miguel, at some point you will disagree with the gatekeeper, and then it will escalate to some extent, and probably some will have to be decided by the Court of Justice. But the question is, there is a bit of a tension, no, between this diversity of solution and needs that the business user have and the compliant solution that the gatekeeper should decide at the end of the day. So how you see that, and do you think the process that is in the DMA could help? So maybe the two of you, maybe also Giorgio, if you have some suggestion on that. So I don't know, Michael first, and then Giorgio, and then the others, if you have an idea. You're welcome, but let's start with you.
Yeah, thank you very much, Alexandre. And I think it ties immediately into the question on, participating and participation of third parties, and how can we bring this together. I think the first point is to be also very clear is that there is not possible to have a tailored solution for every individual business user that is specifically tailored to its specific scenario and concrete needs or specificities. I think we have to be just very honest about that. It's just not possible. So I think this we can address, and what we are seeking are a number of elements. The first element is that the solution should precisely be sort of neutral to a specific scenario, but be sort of sufficiently accessible for a broad majority of users. So again, a very open and, let's say, flexible solution that can work for a large majority of the users. The second thing is consistency. We as the Commission value this and consider that this is a key element, that we are consistent in treating the different gatekeepers, and in particular the different CPSs. Now, obviously, again, also the gatekeeper situations are different. Their business models are different and may require different solutions. But overall, there is clearly an element of equal treatment that we have to and will take very, very seriously in this endeavor. And then on the last point, as you said, it's about designing the process. I mean, a process that can also be that implementation, there is still room for feedback from the business users and third parties to fine tune. In some provisions, we even have concrete obligations for gatekeepers to put in measures for dispute resolution. So I think there are already elements where then a more individualized solutions can be taken up in the constraints that I just mentioned at the beginning.
Thanks. Giorgio, what do you think about that, and what is your suggestion to deal with the diversity of need?
Thanks. Yeah, I agree with your first point about, I agree with your first point about sort of neutrality and sufficiently accessible remedies so that the majority are satisfied. I'm less interested in consistency, because if the onus is on the gatekeeper, then it might be that different gatekeepers make different choices. And so it will not be inconsistency of enforcement, it will just be inconsistency because some gatekeepers make different choices. But provided those those choices are well motivated, then the fact that one gatekeeper does more than another isn't really a concern from an enforcement perspective. It may actually create lessons. So if gatekeeper A does this, then why doesn't gatekeeper B do the same? So you could see a learning process between them. And the third point I'd make is maybe there's an opportunity for experimentation. So you have a go with what is a good faith effort at compliance, and then you see how well it works, and then you revisit it, rather than saying, I have complied today, and what I've decided to do today will last for the next decade. It's more what I've complied today will last for a year, and then we'll take stock and see whether I've over-complied or under-complied.
Thank you. Maybe I can go to both of you, and also maybe Frank and then Richard, if you have some idea of that, because I know you in your previous lives you have dealt with a lot of those compliance process in telecom, and it's not easy. So maybe I will come to you, but maybe Carol and Carolina, how do you see that, and how do you let's maybe start with Carol. How do you prepare for this complex compliance process?
Yeah, it's a very good question. There's a lot of people working on this as we speak, finding some of the solutions or thinking about how solutions could look like. I like this idea of, thinking about or starting off with a good faith effort, trying to find a solution, because also from a gatekeeper perspective, it is in the interest of the gatekeeper to solve these issues. And I think that's, some recognition of the fact of being involved in antitrust fights for years and the challenges that means for the business to operate. You want to find a solution that works in the current environment. And I think the idea of a participatory process that helps to engage with the beneficiaries of those solutions and find a consensus what the solution should be is definitely the right approach.
Okay, and Carolina, you may be on the other side of the fence, so the business user, and there are some obligations that you are particularly interested in. So on your side, how do you prepare to ask for those things, or to have a dialogue with the gatekeeper and with the commission? So how do you see that?
Well, thank you. First of all, as my colleague said, yeah, thanks to CERRE for opportunities like this. Because, when I talk to my colleagues in Italy or to our board, they say, great, there's a DMA, let's get it done soon. And I'm like, no, it doesn't happen that way, right? So this is most a welcome opportunity to delve into the details. But to us, of course, we are more a recipient of the benefits, and we, as I said, before our market, which is evaluated by the European Audiovisual Observatory to be to account for 119 million euros in 2020 and 2021. It has been up for grabs for the lack of rules. So we think this is an opportunity to have maybe not a one-fits-all solution, but in terms of having, for example, one single CPS, one operating system across different devices that allows access to our content, to audiovisual media service content providers. I think that one-fits-all solution can be found, and we hope that it will be found soon enough to make sure that our market stays open, fair, contestable, and with also an important implication for diversity and pluralism and sustainability of European media.
Thanks. Thank you. Now, maybe Frank, same question: how your company is preparing for the DMA effect? I don't know exactly on which end you will be, but so yes, I mean, how are you preparing for that?
Sure. So I don't think the company I work for is likely to be designated a gatekeeper, but just in speaking in more generalities, obviously I echo all the comments about engagement, right? Whether it's engagement internally with your management, your executives, engagement with the commission, or engagement with interested third parties, all of that is crucial to get early certainty on where you want to move the ship, right? These are huge companies. It takes them a long time to get things to go to the right place. I just want to make one observation, which is, I think was it last week or 2 weeks ago, there was the settlement with Amazon, between the Commission and Amazon, on commitments relating to Prime and the buy box. And there was a comment about how the commitments under that antitrust case would ensure sort of compliance or act as compliance with the relevant provisions in the DMA. And it's almost kind of as in-house, I look at that and say, well, at least one company on one particular issue got early certainty from the commission that those set of commitments would comply. Sort of welcome kind of early indication. It's just food for thought. It's a very interesting case to see from the outside.
Thanks. And so maybe Richard, I come to you, and if you can, share your view of how do you see this compliance going forward, particularly on the basis of your previous experience in telecom. And again, if the audience have some question, or if you have some question after, I will give a last opportunity for have some question on that.
The only point I would say is that I think the gatekeepers are going to have to get accustomed to sharing much more data about the effects of their processes that they put in place to build trust amongst everybody that the outcomes of what they say they're doing are as they expect or as they describe. So I suspect that many of the gatekeepers or prospective gatekeepers have been accustomed to sharing data, bilaterally with competition authorities and with regulators, sharing data more widely with third parties, with access seekers and others, in a kind of open data environment to build trust and confidence in terms of the effects of the measures they're taking. I think will be sort of critical and will be a new aspect of the process for many of these firms. Then, of course, there's a question of agreeing what the most relevant measures and data are, which is something perhaps that CERRE will be turning its mind to this year.
Thanks. Do you have some question? Yes, please, gentlemen in the room, if you can just present yourself and then ask your question.
Is it working?
It's okay.
Is it working? Yeah. So thank you so much. I'm Christophe Gatti from Bruegel. I have a question to Michael about the definition of effectiveness, because I have two readings of effectiveness. So one reading of effectiveness is the gatekeeper implement the compliance measure is green, so it comply and it's okay. My second reading of effectiveness is the compliance measure should have an impact. But here, if we consider this aspect, it doesn't mean if, for example, I'm using Google today, Google comply and there is no change because user prefer using Google and not being this integration of ChatGPT or DuckDuckGo. I'm still using Google, there is no change, but Google comply. Is it effective? But there is no impact. So what is your view on that? What is your interpretation of effectiveness, Vim 1 or Vim 2?
Thanks. Michael, and maybe also Giorgio, I would have to hear your view about that because it's an important question.
Indeed, it's an important question. Now, obviously, it's very difficult to answer this in the abstract because it is really a question of the individual obligation, of the individual scenario of the company, etc. Maybe on your principal approach, I think the first point is the DMA is about creating opportunities for other companies. Who takes up those opportunities, whether these opportunities are taken up, in which way, is not for us as a regulator to predetermine. So again, it's about choices, it's about opportunities on all sides, but it's not about designing a particular outcome or changes to a specific company or its success or the lack of its success. So I think there we should be very clear that this is about creating opportunities, possibilities, more choice that then creates possibilities for companies to pick them up. So I think that is a key element that will drive us here. Now, obviously, we will, and this is, I think, what was mentioned in also your recommendations concerning the compliance report. I mean, somehow we'll have to look at what is really happening. So an effect on the ground is obviously part of the compliance monitoring. But I think, and this is exactly where I can fully invite CERRE to continue working, is like, but what could be reasonable and telling indicators for this effectiveness? And again, I think we cannot go to see like, oh, well, we would like to see this and this concretely happening, but we need to be more sophisticated in trying to get a better grip on indicators that relate to the concrete effectiveness without trying to pre-design or pre-choose certain outcomes as the only way to be able to be a proof of effectiveness.
Thank you. Maybe Giorgio, but and also I have another question for you, because Frank had an interesting observation about this transition from antitrust to the DMA, and I think we have a good example that you mentioned, the Amazon commitment that the Commission accepted at the end of the year, and do you think that should be the blueprint for the DMA enforcement? So I would not necessarily ask you to pronounce yourself on this specific case, but more generally, do you think that all those cases which are antitrust cases which are open should be closed with commitment, and then that should be in a way the first DMA enforcement, or do you see risk in that approach? So two difficult questions, but I guess you're well placed to answer.
Fine. I mean, obviously, there are a number of other pending cases where the line of attack in the antitrust world is exactly the same, mirrors the DMA. So, I mean, you have to be a little bit careful, because the DMA sets specific obligations, and perhaps the antitrust concerns are broader than the DMA. So it might be that just to close a commitment decision saying, oh, look, I anticipate complying with the DMA, but I get rid of some of the other competition concerns that exist. So there's a risk of under enforcement if you only accept commitments that relate to the DMA and not to broader antitrust concerns that are not covered by the DMA. So a case like Amazon fits nicely, I think, because actually most of the competition concerns mirror provisions within the DMA, but it may not be the case in all scenarios. On the question that you had, yeah, it's a great question about what is effectiveness. Is it just the process, or is it also the outcome? And I'd just like to make one reflection on this. If the outcome isn't there, right? So the gatekeeper has said, well, I will do this and I expect switching, and then the switching doesn't occur. I mean, there may be reflection. Is it the DMA is poorly designed, right? The obligation is wrong. We should have designed a different obligation in order to achieve the result. It might be that people are accessing in a different mechanism. So the market actually functions in a different way because things have evolved and people don't switch necessarily from Google to DuckDuckGo, but they search in a completely different way. And so in a sense, the market has moved on. Or it might be that there's compliance is wrong and should be improved. But there, if a gatekeeper has, in good faith, consulting third parties, given an opportunity for entry, and after a year, you realize entry isn't there, and you discount the DMA is badly designed, you discount there are other market mechanisms that facilitate market access, and you say, therefore, it must be that it's poor designed remedy, then that's just a recommendation for a duty on the gatekeeper then to rethink its compliance effort, because it's clearly not been sufficient. But you wouldn't in that situation penalize the firm for breaching the DMA when they have made all efforts procedurally to make a good stab at compliance.
Thanks. Other question from the room or from the audience, from the online audience? No. Do you, Carolina, do you want to react on what you have heard so far? You want? You don't want? If you want to react on what you have heard so far, we are closing. So this.
Well, as other I've said, we just. And it was also confirmed by Vice President Vestager that regular antitrust should eventually complement what the DMA is set to do. So I think that in that sense, we are in good hands.
Okay, and that's also the beauty of those on-site conference, because I saw Thomas Cramler nodding when he said that there is a risk of under enforcement if you just say, okay, the commitment under DMA is enough for antitrust, and it's true that there is more in antitrust than in the DMA, and I think that is very clear, and that is why, as it is often said by DG Com, we may expect to have a continuation of the activities of antitrust. There is one question from the.
Yeah, I will try to read it from Batuan Tunsel. Should somebody put setting of criteria regarding the requirements and content of annual reports in order to overlap this compliance stage with aim targeted, or instead of putting sets of criteria regarding the content of compliance report, should consensus regarding the content develop case by case?
Yeah, so I mean, the question, I think, if we may paraphrase it, is first, will the Commission give a template of the compliance report or not? And what should be in? So maybe for the template, Michael, you can reply, and what should be in. Giorgio, you can have an idea. I mean, you have an idea.
So yeah, we of course get regular questions on what other guidance and the like the Commission is still going to publish in addition to the more procedural rules that have just been brought out. And I think the first point is to say that if anything, we're looking indeed more towards procedural elements rather than on the substantive questions. So I think it is unlikely that before we gather some sort of enforcement and also compliance experience, that we will give guidance on the individual qualitative obligations in 6 and 7. Now, on the other elements, that is still indeed a process which is ongoing on our side, where we wouldn't exclude at this stage to come up with further elements where it could be useful to give a structure, let's say, to third parties. The compliance report is not the only one. There are several other elements where things have to be submitted to the Commission, where there has to be reported, and we are in a process of reflecting which ones are really would benefit potentially from further clarification and structuring. But this is, again, a process still ongoing. So again, a space to be watched.
Thanks. And Giorgio, what should be?
Yeah, good question. And I think, first of all, generally, we don't know. And I think we should allow for some divergence and experimentation as to how these reports are designed. But two things. First of all, they should be useful for third parties because they need to be able to see what is the key through which I get access, right? So the public version of the report has to be really technical and understandable for third parties to say, okay, I want to go through this gatekeeper. This is the process I need to do in order to get there. So there needs to be a lot of clarity there. Also, as was mentioned before, informal dispute settlement processes are necessary to accelerate the access. But the other thing I would like to see is some sort of narrative. So the story of how the gatekeeper made the choice of this particular technical implementation. So as somebody said before, to persuade the Commission that this is effective, right? So, and the story can involve many elements. This is a study we've done. This is an A/B testing we've carried out. This is the consultation we've done. These are the outcomes of the consultation. Therefore, this is the technical specification. So some sort of storytelling would be quite effective, I think, as a mechanism for persuading the Commission of effective compliance.
Thank you. Yes, Carolina. And then maybe, Richard, I will give you the last word as a co-author of the paper. If you have some final remark or takeaway, Richard, I will give you the word after Carolina.
Just one quick reaction on Giorgio's narrative and storytelling on compliance reports. I just caution against what happened with the code of conduct on misinformation. So we hope that this will not be used in a way to mislead third parties and the Commission, but that and I think the Commission did a great job in shedding light to obscure practices. So really hope that these compliance reports will be helpful to that. And thank you.
Thanks. Final question, remark? No? Okay, then we will do the break for 30 minutes. And so we will start again at 4 o'clock on the obligation of self-preferencing and switching tools. So a coffee is served just in the room next. Thanks.
No, we never.
Just online. So nice to meet you.
We. Okay, let's start again slowly. So we have a very packed panel. Yes, I don't know if Martin is online, Martin Pates, and if we can, yeah, okay. So thanks for everyone for coming back. So here in this second panel, we will focus on some obligation. First, the one on self-preferencing, for which Martin Pates has drafted the issue paper and the recommendation. So he will present them in a minute. And then another series of obligation on switching tool and choice screen. Amelia Fletcher did the recommendation and the report, but she's traveling so she could not present. So I will present for her in her name. And then we will have the reaction of a number of panelists, and we will do that as the previous panel. So I will ask them in 3 minutes to give their view on what they liked and what they like less in the report. So we will start with Aurélien Maël from DuckDuckGo, then Georgios Mavros from Google, then Ben Schroeder from Booking, and Vanessa Turner from Böck. And then we will finish with Thomas Crummler from the Commission. Okay, so Martin, the mic is yours to present your recommendation.
Thanks. I would like to see the screen.
Okay, we see you on the screen, but we don't see the slide. Okay, now we see you and the slide. I don't know if you see, Martin.
I'm perfectly informed now, and I hope you see as well as I do. Yep, thanks for having me virtually. Yeah, it's a pity not to be around now. Talking about self-preferencing, for those of you who have looked at the issue paper, so I'm focusing, or this issue paper focuses on Article 6.5 as it appears on the slide. So it says the gatekeeper shall not treat more favorably in ranking and related indexing and crawling services and products offered by the gatekeeper itself than similar services or products of a third party. Gatekeeper shall apply transparent, fair, non-discriminatory conditions to such ranking and related indexing and crawling. So at a first look, this might seem rather clear, but I think there are many things which need to be clarified to be able to work with Article 6.5. The first one is about, well, treating offers by itself relative to third parties. And there are different scenarios which are possible. One you may immediately perhaps think about would be in the context of e-commerce, that an e-commerce platform has its own products that it sells, and then there may be some differential treatment between its own products and those of third parties, the way end users see those offers. So that would be my scenario one, and I think that's obvious. However, there's another scenario where the differential treatment applies to business users as the targets, and that's the case if the platform has vertically integrated services it offers, which in an e-commerce setting could be, for example, logistics or payment. And in other environments, it may be, say, services provided in EdTech. And also in that case, self-preferencing may apply when they are often small business users being offered a variety of services, and those services are treated differentially. Self-preferencing may also be an issue if we have those vertically integrated services, and it's not that business users have a problem with seeing all the offers in a transparent and non-discriminatory way, but that business users who do not use first-party services may lose some of their visibility with respect to the end user. So these are kind of three broad scenarios where self-preferencing may be an issue, and I wanted to highlight that we should think about all this. Now, the other issues which I think have to be clarified, and that relates to what it actually means operationally, that something is treated more favorably, because not all things are equal. And of course, we want to, it's clear if we see equal things and one is treated differently than the others. However, things are not the same. There is room for interpretation. I would like to move on to the next slide. So I think what this initial discussion and a large part of the discussion in the issue paper suggests is that this prohibition should not be used as carte blanche. It's very dangerous to engage in a mechanistic enforcement. Instead, one really has to look closely at the particular practice and whether this practice is what one might call true self-preferencing, which is indeed a differential treatment, even though, or more favorite treatment of own products, which cannot be justified based on consumer preferences. And one issue where I think the article is unclear about is whether the obligation applies only to the design of rankings and as a non-price strategy in this differential treatment, or whether they also pricing elements should be included. And at least I wouldn't call it a recommendation, but a suggestion is to reflect about whether it is perhaps useful to you to have Article 6.5 being restricted to non-price strategies. As I mentioned on the previous slide, there are different scenarios, and I would argue for a broad application so that the prohibition should apply to treatments both on the end user side, directly or indirectly, as well as on the business user side. And I think the big challenge in implementing prohibition is to distinguish between what one may call true self-preferencing as opposed to a legitimate differential treatment. And so I think in practice, large part of the discussion should focus on this distinction. There, I think economics can play a useful role, both on the theory side as well as recent empirical work. First of all, to define the scope and also distinguish the different natures of differential treatment, to what extent it should be seen as true self-preferencing, in which sense it should not, where it is important to include also dynamic considerations into the analysis. And I think I did it within my time limit. I want to stop here. Thank you.
Indeed, thanks a lot, Martin, for that. And of course, you remain with us for the debate. So now let me turn to the other issue paper on switching tool and choice screen. And here Amelia, and I hope I don't make mistake in transmitting you her thinking, but in any case, you have the report on our website. Her recommendation is really about three main things, and if you go to the report, you will see that we were trying also to organize, let's say, the recommendation around those three main issues. One is a legal clarification on the scope. So what we were trying to show is that some issues were maybe not totally clear at first reading, and therefore some clarification may be needed and will be brought as the DMA is enforced. Then a second number of issues relate to effectiveness. I mean, we all heard Andreas Schwab saying that effectiveness is more important than proportionality. No, I'm not so sure, but okay. Anyway, effectiveness is important, and so it's important to have some effective mechanism to enforce the law. And finally, but importantly as well is to be careful of some unintended consequences of the implementation of some obligation. Now, regarding the specific series of obligation which relate mostly to Article 6, paragraph 3 and Article 6, paragraph 4 of the DMA, in terms of legal clarification, it was not totally clear to us whether non-standard browser like search app or in-app browser are covered. We think they are, but clearly this is an issue which may be subject to contestation, and so we think so. Therefore, it seems to us that some clarification that they are could be interesting. Another thing is whether other services than browser or the one which are mentioned, voice assistant and search engine are covered or not. So for instance, within browser default, whether they are covered or not, that's an issue that could be discussed. And finally, and an important question is whether non-proprietary default, so a default which are provided on a contractual basis, should also be covered or not. We think they should not, but again, this is something that needs to be discussed. The second series of issues are about effective mechanism. It is clear that switching tool needs to be designed in a way which will lead to switching, or at least to the opportunity of switching. To come back to the discussion we had before, and Michael was clear that it's about creating opportunities. And if those opportunities are not taken, so in this case, if the switching are not taking place, we have to understand why. Is it because the law has been drafted not well, or because the switching tool in this case are designed in a way which is not effective? But that seems to be important to think about. We think also that there should be a possibility to reverse. So if you decide to switch from one company to another, you should be able, if you are not happy with this switch, to come back to where you were before. And also, it seems to us that this possibility of switching should be there every time you use a new device. And also that no charge should be imposed. Now, again, those are things that will need to be clarified in the enforcement, but it seems to us that that will make the thing effective. And finally, about unintended consequences, it is clear that there is a risk, and we have seen that in other industry where the switching has been possible, like for instance in telecom, there is a risk of misleading third-party prompt or slamming, and therefore here we have to, and in dialogue, the gatekeeper in dialogue with the business user and under the control of the Commission should find way to alleviate that. There is also a risk that we have excessive prompt and choice fatigue. I mean, we all know the story about the cookie, which is a disaster, as we know, and it would be a problem that the same kind of things happen here. And finally, and this is something also where we have to be careful for that series of obligation, but more generally, is that, of course, if the role is to create contestability, we have to be careful that the implementation of those obligations do not harm small platform or services which is relatively small compared to others. So it's very clear that by opening the default or by facilitating switching, it should not have as a consequence of harming smaller platform or small CPS compared to the others. I think those are the main recommendations that Amelia would have told you, and now we can move to the debate. And so I will start with Aurélien at DuckDuckGo, because you have a lot of experience also of what is a good architecture and design for switching tool. You have done a lot of experiment for that, and so your assessment of our recommendation would be most welcome.
Thank you very much, Alexandre, and the whole CERRE team for a very interesting and important project over the last month. I'm very happy to be here for the concluding event of this effort. So I represent DuckDuckGo, a privacy company that operates the third largest search engine in Europe, which means obviously that we operate in a market where the dominant player has over 90% market share, 95% on mobile. And that's a reminder of how important the DMA's choice and switching obligations are. Because in a world where the interfaces are controlled by the incumbents, user acquisition by competing firms is a challenge, or said otherwise, in most cases, users don't get to choose their search engine default, their browser default. This decision is made for them. What we really like about Amelia's report is the holistic view that she took about the DMA's choice and switching obligations in a way that, to a good extent, echoes the 10 principles for fair and effective choice and switching mechanisms that we published with other search engines, and which, in effect, come down to a simple idea. Users should be able to freely and fairly choose their search engine defaults and switch later on just as easily. The catch here is that on a device, and especially on mobile, you have many different places where you can search the web, many different search access points on the default browser, the search bar, the voice assistant, you name it. And there is no simple, easy button to switch all of this at once. The Android choice screen that already exists, and that is a result of the action of the Commission in the competition field, already allows some of this. So already affect some of these access points, but partially not all of them, and only at the onboarding phase. There is no, in fact, such easy switching button later. It is our view that the DMA should be understood to fix this. It's something that Amelia clearly explained in the report, and that we fully agree with. My second point is that these choice and switching mechanisms should be free of charge, just like it is on Android. The reason is that if these mechanisms are not free of charge, and that if Gatekeeper OS and browsers are able to get a cut of the search revenue, then they will be incentivized to favor Google, that has a much higher unmatched financial might on the market. So the DMA should be understood to end these self-reinforcing dynamics of dominance, and we are really eager to contribute with testing and ideas in this process.
Thank you very much. Georgios, no, from Google.
Yeah, so it's my turn. Thank you. Thanks. Thanks, Alexandre.
Wait, I will give you the mic.
Hope you don't count my time. Yeah, I hope I still have 3 minutes.
1 minute.
I have 1 minute. So I have 3 minutes on 2 extremely important DMA provisions for Google and no mic. I hope this is not a nomen for the way the DMA, the next steps of the
preference.
Exactly.
Self-preferencing in reverse.
So yeah, I mean, thanks for the invitation. And obviously we do support the whole process, and we do support the 2 issue papers which are subject to this panel. 3 minutes not enough, so I'm going to go as fast as possible. When it comes to Amelia's issue paper, we are in favor of openness and choice, as long as choice is relevant for users, and obviously as long as choice does not undermine the user experience. It needs to be designed in a way which does not affect the experience that users have when they use our services or other digital services. Let me move now very quickly to self-preferencing. It was, again, a very interesting issue paper, and we support this report. One question which has not been debated, and it's brought into the public debate, but this report is the question around the definition of separate or distinct services. We should not be in a situation where every new feature or a product change is captured by the DMA. Digital services will evolve and should not be freezed on formats or technologies which basically come from previous decade. And I think this is one of the areas where the definition of a separate service can be useful. The issue paper also helpfully calls out the distinction between self-preferencing bias on the one hand and legitimate differentiated treatment, which again, it's something important to keep in mind. And it also highlights the different incentives that a company which uses a platform has, which is actually to maximize its profits, whereby and on the other hand, actually, a company which provides the platform needs also to cater for the interests of the wider ecosystem if it wants this ecosystem to thrive and this platform to be successful. Ultimately, whatever the circumstances of the market, whatever the name of the company or where it is located, when it comes to ranking and search specifically, the interests of users, intermediaries, and end business users, restaurants, coffee shops, hotels, and so on and so forth, do not necessarily align. So more visibility for some will inevitably mean less visibility for others. Hence, we do need, and this is something which is advocated by in this report, we probably need some sort of economic assessment to understand where we should draw the line and make sure that we manage to have the necessary trade-offs between these different stakeholders. Thanks.
Thank you very much for calling the economic analysis, because that's also a big question, whether the economic analysis is out of the way because we throw out the efficiency defense. And clearly, I think efficiency defense and economic analysis are not the same. And so it would be indeed, I think, very important. And in fact, that is one of the reasons why Amelia is not there, because she's in parallel talking about the role of the economist in the DMA enforcement into laws. And so the thing is that indeed, I think, and the report by Martin shows that very well. But of course, Martin, you are biased yourself, or maybe you are self-preferencing yourself as an economist, but we still need the economic analysis, and it will be important to see what are the points like this one and others where the economic analysis will still be relevant. So thank you very much for underlying this point as well. Now Ben from Booking.
Yeah, thanks for having me. And first of all, thanks to you, Alexandra, for putting together this research project, and thank you also to Martin and Amelia for these really stimulating papers. I think they add a lot of value to the discussion. So I'm going to focus my remarks on self-preferencing. I think in a certain way, the self-preferencing obligations are foundational to the DMA. Arguably, if you hadn't had 7 years of the Google Shopping case, we might never have gotten to the DMA, because it was a long time frame of that investigation that I think brought a lot of people to the other side of the fence in concluding that we needed a complementary tool to competition law. And we have also seen at the DMA workshop on self-preferencing a couple of weeks ago that a lot of the complaints about Google self-preference in other sectors are still unresolved. And I think what that tells us, the duration and the larger number of still unresolved issues, is that there's a lot of complexity in dealing with self-preferencing, in particular when it gets to compliance solutions. And I think this is where I see the most value in Martin's paper, because it really focuses us on the core issues that will be at the heart of compliance. And to me, these are two. The first one is, what's a separate service? There's no clear definition in DMA, but that answer is extremely important, because without a separate service and some sort of vertical integration, there can be no self-preferencing. So I think we will see a lot of discussions around the delineation of CPS, and we'll also see, once the CPS has been defined, a lot of discussions around what constitutes a separate service. The second point is, what should be considered differential treatment? And I do think Martin has a very important point in calling for contextualization in this context. Ranking is always subjective. Like, there is no objective standard. I think we need to just realize that there will always be value choices involved, and these value choices are also a parameter of competition. And just to dwell upon a little bit one of the examples that Martin gives in the paper, if you have a dual marketplace, and let's assume for a second it's a marketplace that sells a very basic good at a very low price, what if one of the key parameters of ranking is price? Is that then a form of self-preferencing, or is that a legitimate use of the ranking algorithm? So I think Martin is right in calling for a nuanced approach. And I think he's also right in calling for taking economic insights into account. And you're right, Alexandre, there can be no efficiency defense, right? Like, I mean, that ship has sailed. We're not in competition law here. But I do think there are some insights from economics that can inform enforcement in the DMA when it comes to self-preferencing. And that's going to be extremely important in ensuring we have long-run contestability of markets and the consumer interest is sufficiently taken into account. So I'll leave it at that for the moment.
Okay, just to understand well, so you say long-run contestability on the market, huh? Yeah. Okay. No, because I think that's important. I think we may also see in a way the DMA as moving from short-term efficiency, which has been the focus of antitrust more recently, to long-term efficiency or long-term contestability. But so this is a shift in temporality, but that doesn't mean that economic analysis is again not relevant, but it should be maybe relevant in a different way. And then Vanessa from Berg.
Thank you very much for the opportunity to join you today. Sorry, yes. Is that better? I'll sit up a bit further. So thank you for including end users, well, in the form of consumers who I work for, in this debate, because I think they're an important voice that also are meant to be beneficiaries of this legislation. So is it still not working? Okay, let's try that. Right. Okay, so what do I like in the papers covered by this panel? That's quite a difficult question, but only in the sense that I like pretty much all of the recommendations in the switching tools and choice screens paper. So it's quite hard to single some particular recommendations out. Cutting the paper a slightly different way to the way that Alexandre did, the paper covers essentially two main areas: defaults and the effects that they have on consumers, and choice screens. So both of those are of direct relevance to consumers or end users. Aurélien has covered some kind of points of principle about consumer choice, and I agree with everything that he said. So I'm going to focus on some more points of detail in the recommendations, both on the defaults and the choice screen. So first of all, on the defaults, and I'm not sure that Alexandre mentioned this one specifically, but I very much agree with the view that the obligation on gatekeepers under 6.3 to allow end users to easily change their default settings should apply to all products or services for which there's a default setting on the gatekeeper's operating system, virtual assistant, or web browser. So this ability to be able to easily change shouldn't just apply to operating system, virtual assistant, web browsers, but also things like mail, calendar, audio players, and so on. So I think that's a recommendation that I very much agree with. And I also very much agree with the recommendations on the design of switching tools, which Alexandre call out. So what choices consumers should have and how these should be presented to consumers. And those recommendations, I think, are quite key. But I particularly want to highlight the recommendations on the choice architecture of the choice screen, again, under 6.3. And there, the report calls out that the Commission should think about setting high-level expectations. I think that's a very good recommendation. Also, seeking the input of third parties, a theme from the previous panel, and reviewing gatekeepers' A/B testing of their designs of choice screens. Commission perhaps doing its own testing or considering other independent testing. So I think those are key things to get the choice screens to work. Then turning to something that I like less, and here I'm going to maybe bring some more controversy into the debate. I'm a little bit more dubious about the recommendation that we should use guidance from economics in the self-preferencing prohibition. Obviously, we don't want self-preferencing in the prohibition under 6.5 to harm interests of consumers neither in the short nor in the long run. But and it's already been said, I do think that that idea of using economic theory is dangerously close to efficiency defense arguments. And whilst those are obviously perfectly legitimate under competition law, as has already been said, the DMA has already made the choice on efficiencies. And it has chosen to draft the prohibition in 6.5 in a very specific way to cover certain types of self-preferencing from a broader range of potentially beneficial, but also potentially harmful self-preferencing practices. So although the report recognizes this, I'd like to see some more clarity on how you can actually draw the line between the type of economic arguments that are being discussed and efficiency defense. And I think perhaps more important in making this provision work is lies not in economic theory, but in testing how the implementation of the self-preferencing is done on consumers' reactions to the way the information is presented to them. And I won't go into the true self-preferencing. I think it's an interesting topic and an important topic, but I'm done my 3 minutes.
Thank you very much. Thank you very much, Vanessa, for that. And so may I remind the online audience that you can send your question through the Q&A function in Zoom, and then we will take them after the last intervention by Thomas from DG Comp.
Yeah, we have to start with a big caveat. Obviously, I cannot give you the authentic interpretation of the DMA from this point here. What I can do, and I will try to do, is with the knowledge I have of the genesis of the DMA, i.e. the proposal and the legislative history, to make some sense, if I might say that way, of the rules, and to give you at least what you can draw from these two sources of information. Let's first start with self-preferencing 6.5, as has already been mentioned. How we see it, there are three really key issues that need to be tackled in this provision. There is the question of similar services. What I like in the report is that it very much looks at the user perspective, but the user perspective also has some drawbacks because we all have been trained by these services. And what a user a couple of years ago might have considered a separate service might no longer be a separate service in the user's view now that they've been acquainted with certain services. So there's a kind of inbuilt bias which you need to be aware of when you deal, when you just look at the end user perspective. Therefore, and that I missed a bit in the report, what about the business user perspective? Are there business users out there who be able to offer a separate service which basically replaces or can compete with the service that is offered by the gatekeeper? So both perspectives, I think, need to be taken into account. Favorable treatment, second point. So how do you interpret the notion of favorable treatment? As Vanessa already said, the legislator in the DMA has taken a very deliberate decision not to cover all forms of self-preferencing in Article 6.5, but only to cover a very specific notion of self-preferencing, which is self-preferencing in ranking, on the assumption that self-preferencing in ranking is in most of the cases, and there the legislator takes a blunt, broad brush view, is in most of the cases problematic. And therefore we have I think a much blunter rule than the report suggests. Namely, not a rule which is based on what would be the consumer preferences, where an authority like the Commission would have to second guess basically what consumers would like or would not like. And we'd have to establish whether it is not self-preferencing if a majority, and what is a majority, by the way, of consumers would like a certain presentation of a product, then it would not be self-preferencing. And if a majority does not like it, then it is self-preferencing. That seems to be not a reasonable way forward to interpret this provision. I think the legislator has been much more blunt. Self-preferencing in ranking, if it occurs, is outlawed by the DMA. And therefore, whether a gatekeeper could show that in certain cases consumers prefer the way the gatekeeper wants to present the product or not, I can't see the particular relevance in the interpretation of 6.5. Ranking is subjective. Yes, I fully agree. It is subjective, but that doesn't mean that algorithmic treatment needs to be subjective. Algorithmic treatment can be absolutely objective. The input that the algorithm treats leads to the same output, irrespective of whose product is subject to the algorithm. And that can be tested. That can be A/B tested. That can be subject to scrutiny. And that's probably the benchmark that we should look into when it comes to favorable treatment. Price or non-price was another issue. So there is the provision in 6.5 that the conditions have to be front, which seems to me an indication that price needs to play a role in the assessment. So I would not be as blunt as to say that only non-price considerations play a role in Article 6.5, because the front provision needs to have some meaning in Article 6.5 last sentence. So I guess pricing will also have to play a role in the assessment. When it comes to Article 6.3 and 6.4, what I particularly liked to start with the positive side of things is the focus on choice architecture and how things are going to be presented, because I think in the implementation, that will be one of the most important things if you want to make this work properly, that consumers actually do interact, do appreciate the choices and do act upon the choices that are offered. And that this is a neutral choice architecture where consumers are not misled, where consumers are presented with neutral choices, and there's many sorts of tricks, if I may say so, that can be implemented in order to nudge consumers. And I think, therefore, it's quite important, and there the compliance reports that we have discussed previously will be very important in terms of what kind of A/B testing will be required from the gatekeepers. What do we want to see in terms of testing the consumer reactions to certain choice architectures? And Article 13.6 of the DMA, which talks about neutral choice architectures, is probably the provision which we can rely on in order to implement this together with the gatekeepers. What I found a bit more blurry in the paper is the difference between being able to switch defaults and choice screens. Because what I read in the paper is that the suggestion is that the easy switching of the defaults also should come with a list of products that you can basically choose from. And question that I have, what's the difference between that and between a choice screen? I mean, the DMA has deliberately limited the choice screens to a certain number of products and not enlarged the scope of the choice screen obligations to all sorts of products. So that must have a meaning. The legislator must have thought that this differentiation makes sense. The way I see it is it makes sense in a way that the legislator didn't want to overburden consumers with lists, choices. There's the choice fatigue that you mentioned, Alexander, rightly so. So therefore, choice screens are only limited to the products that are listed in 6.3 third sentence, and we don't have choice screens when it comes to the default settings. I think we need to keep this difference alive in order to implement the legislator's choice appropriately. I think I'll leave it at that for first comments. Thank you.
Thanks a lot for this very precise reaction. So maybe I can come back to Martin because you have heard several comments on your paper. And so it would be interesting to hear your reaction to that.
Yeah, first I was very disappointed that initially the panelists seemed to like and not much to dislike, but thanks to Vanessa Turner and Ms. Grumler, I'm now in a position that there are also some negative statements. That's good. And I think, first of all, well, I'm not sure whether that's the right forum to talk in detail about the role of economics in the enforcement, especially of 6.5. I do have a clear bias, as Alexander anticipated, that I think economics does provide us a way of framing problems, possibly discovering, understanding what problems are, and then, of course, ideally to test them. And I think that's what will be the challenge. So we will need some testing. And I hope that's at least also in line with the legislator, because otherwise, if every business user can complain not being fairly treated because it's clearly inferior, I want to say a different word, but it's clearly inferior product isn't treated at equal terms, then I think we are really running into trouble, and we're introducing a lot of inefficiencies. So I think it is clear that we do need some criterion at which point a particular practice constitutes self-preferencing or not. And I think the problem, and that will be part of the discussion when implementing, will be that first-party offers may be in some dimensions systematically different from third-party offers. And that's the case, then you can use those features, of course, as part of the algorithm to select that. And there one needs to draw a line between what part of selection is admissible and which one is not. And one way of doing it is to think about what end users like. And it doesn't need to be the majority, especially if we have personalized recommendations, that there's no meaningful way to talk about the majority, but there must be a way then to think about how to select certain practices and label them as violating the prohibition compared to other practices where we would say that that's what consumers actually want. And this actually want, I do understand there may be a concern that consumers may get trained to a certain way of seeing things, but in the end, the Commission will have to make a decision, and just kind of focusing on what are the complaints of third-party business users, that's probably not the ideal guidance to make those decisions.
Thank you. Thank you very much, Martin, for this reaction. So now, is there some question? After I will ask to every one of you to react to what you have heard, because I think it may be interesting to have another round among the panelists on what has been said by each other. But first, do we have some question? I don't know, we know on online or in the room. Yes, Antonio. So if you can represent yourself, because maybe
yes, Antonio Manganelli, University of Rome, and about self-preferencing, I think it's very interesting and fascinating. And of course, the algorithm. I mean, the ranking is subjective on the consumer side, the demand side, but the aim of the provision is to make the ranking objective on the supply side. So meaning that it leads us to think about what is the counterfactual. So the counterfactual is not, according to me, to see if a different ranking is better or worse for a consumer, because of course also it's very subjective, and you should also check for each consumer, because each consumer will have different preferences. The counterfactual could be to see whether changing the gatekeeper and not having the gatekeeper in the ranking, but another company, third party, would alter the ranking. So on the supply side, so the objectiveness on the supply side. And this will lead to the, let's say, self-enforcement of the regulation without having to assess any effect, or whether it could be an effect on competition, or whether the consumer welfare is affected. So that's my interpretation. Sorry, it's not a question, it's more a comment, but I would like to have a reaction from Martin and also from Thomas, if it's possible.
Thanks a lot. Other question, I think, yeah, it's a very valid point. And other question in the room, or comment, or idea for self-interpretation, for self-enforcement? No? Okay, so maybe Thomas, if you want to react to what Antonio said, and Martin, then Martin also to and then I will do another round, and maybe a last round probably of the panelists.
Yeah, let me come back to the concept of opportunities. I mean, if the DMA is, as Michael has pointed out earlier, is about creating opportunities, then the question in this context arises, who decides who gets the opportunities? So is it the gatekeeper who decides which products are superior, and therefore which products are going to be presented to the users? Or is it the user's choice to prefer some of the products which are equally, in an equal manner, presented to them? And I think if I were to be asked, I think it should be the user's choice and not the gatekeeper's choice to make these presentations. And that's what should be the aim of the DMA ultimately. And there I very much agree with your remark that obviously ranking will always be subjective. There will be criteria that you need to input in order for the algorithm to do the ranking. But then what should not happen is that these criteria work differently or are applied differently to products of a gatekeeper as compared to products of a non-gatekeeper. And that you can test and that you can look into. That should be the main raison d'etre, as I see it, of Article 6.5.
Thank you. So I will do a last round and then a last word to Martin Bates. Ben.
Yeah, maybe if you can just briefly react to what Thomas was just saying. I think there's no disagreement here. I think we need to be conscious that there will be subjective criteria in the algorithm, and that's good, and they will evolve over time because products will evolve over time. But it's I think the fundamental fairness criteria is that same things are treated in the same way once the subjective choices have been made. And I think if that's what we can agree on, then we've already moved a step forward in the discussion.
Thank you, Vanessa.
I'm also going to agree on that particular point. Well, I wanted to maybe go back to one point, if we have time, on Thomas's point about the difference between choice screens and defaults, as raised in the report. I still, the way I interpret the report is slightly different in the sense that in the default list of choices, it's a different principle to the choice screen, where the choice screen is going to be the major suppliers, whereas on the defaults, I think the report was suggesting that if you have installed a number of different options, then the defaults should say, you've got these on your phone, which one do you want to make your default? That should be the ability to choose a default. So it's not the same as the choice screen, but so it's not like a list of the major suppliers, whether you've pre-installed them or not. But it's something that you've kind of pre-selected and you decide which of the ones you've got on your device that will be made the default. So I agree there is a distinction between the default and the choice screen, but I think I support the report in the slight nuance there.
So now we have a disagreement on the interpretation of the report, and not so much on the DMA.
I'm glad I'm being controversial.
Which is quite another level of.
But you can give the authentic interpretation.
Yeah. Well, no, that's the problem. Amelia is not there, so I cannot do it. Anyway, no, but I tend to agree. I think it's that, but again, I mean, Amelia is not there, so I would not dare to. But we will rediscuss that internally because we will have another project that Bruno will explain in a minute on the DMA, and I think it's a good thing that you mentioned that. Georges.
Yes. Yeah. One remark on self-referencing again. Sorry, coming back to this. I mean, from our standpoint, obviously, and at a high level, search engines basically organize information and propose search results based on a query that has been introduced by a user, and search results are displayed in useful formats. This is something that has already been done, and we hope that it will still possible to do in the future. In doing so, in actually proposing these, let's say, results in useful formats, different signals are used. So if you display something on maps, for example, you will have some signals such as location or proximity, which will be taken into account and which have not been taken into account had we displayed these results on a different format. And in introducing product changes, even today, we actually carry out extensive testing. And I mean, by testing real people, right? Not just sitting ourselves and discussing about that. So basically the idea is to what extent we will still be able to have the ability to offer that kind of useful formats. And I totally agree with the previous statements on subjectivity of search results, but objectivity when it comes to algorithmic, let's say, transparency. Thank you.
Thanks, Thomas. Okay, no, yeah, and then Aurélien, and then Martin.
Thank you. Yeah, I just want to say that I agree with very much with what Vanessa and Thomas said on the choice architecture. Simply put, companies test all the time interfaces, how they work with users. I'm sure that choice screens have been tested before, maybe not in the way of facilitating user choice. And the DMA is the moment to do this and to demonstrate in the compliance reports how this is being done, and to also involve other parties in that testing. So I think that's a crucial dimension of this part of the DMA.
Thank you. And Martin, the closing word for this panel.
Thanks. Unfortunately, I will return to self-preferencing. So I think my general concern is about the risk of some kind of over-enforcement. Now, however, when it comes to this the issue of non-discriminatory treatment, so I think it's clear if all the inputs into the algorithm are the same except the identity of the party, whether it's first party or third party, and that matters for the ranking. I mean, that's a clear violation there of the self-preferencing prohibition. And there we don't need to be concerned too much about what really consumers think about it. So I'm fine with that statement. However, if we restrict the interpretation of this prohibition to at this level, I think then we're actually running the risk of under-enforcement. And the point is that first-party providers may well have a comparative advantage in providing certain features. And if those features are then prominent inputs into the way the ranking operates, then even though the ranking is non-discriminatory based on those inputs, it clearly leads to self-preferencing of first-party content. And that's where I think we need an analysis, an empirical analysis to understand what is actually in the interest of consumers.
Thank you very much, Martin, and thanks for all the panelists here. So now we will move to the third and last panel on access to data and interoperability. So thank you very much.
Such an extent.
Okay, so it's a long day. I'm sorry for that, but there is a lot to cover, and so thanks a lot for bearing with us, especially because there is then the speech by Rita, the takeaway by Rita, and then the surprise that Bruno announced, and we are all eager to know what it is. Now, so here we focus on another series of obligation, which are around data access and interoperability. So Andreas Schwab mentioned at the beginning of the conference that interoperability is important for the parliament, and they will watch it very closely, what happened in this space. And so it's important we discuss that. So we will start again by a presentation by of the recommendation in the report. Mark will present the one on interoperability because he's the lead author on those. And then I will present the one on data access, data portability, and search data access. Jan Kramer was the lead author on that, is the lead author on that, but he couldn't make it because he has a course at the same time. And so I will present the recommendation, and then, as we did before, we will ask our panelists to react on those and then have a short debate. So, Marc, the mic is yours.
Thank you, Alexandre, and good afternoon to everyone. So, let me start with these recommendations on interoperability. So, the objective here is to maybe highlight a few of the key recommendations we make in the report. So there are others that I will don't talk about today. So the first set of recommendations that we have is concern some legal clarifications that we think are needed. So in the DMA. And so the first one is about the geographical scope of the horizontal interoperability obligation. So the question that we have is whether the scope is European only, that is the obligation requires any user based in the EU to be able to communicate with any other user also based in the EU? Or is the obligation more global? That is, it would require any user based in the EU, for example, to be able to interact with any other user anywhere in the world and possibly outside of the EU. And of course, we think it has very strong implications in terms of effectiveness and implementation of this obligation. The second legal clarification we think is needed concerns the vertical interoperability obligation, so Article 6.7, so if I am not mistaken. So we think that this provision is interesting, important, but it's also very broad. So the gatekeeper actually may receive very different types of access requests from third parties, asking to have some access to very different types of essential functionalities. So we think that to make this provision effective, there should be some screening, some sorting out of these requests. And so we recommend that there should be a process for handling these requests from third parties efficiently. And one approach that we advocate would be to allow the gatekeeper to define this process under regulatory oversight. So the second set of recommendations concern the effective mechanisms for the interoperability obligations. So the first idea that we have is that for vertical interoperability, there should be a definition of the technical terms of access, and typically it's going to be relatively complex from a technical point of view. And so we think that the gatekeepers are the better place to do that, but they should follow an equivalence of input principle when it is proportionate. And what do we mean by that? We mean that, so in the same way as it has been implemented in the telecom sector, an access seeker should have access to the same functionalities and on the same terms as the gatekeeper for its own complementary products and services that rely on the same essential functionalities. So it may be that this equivalence of input principle is not proportionate, and in this case, we advocate for an equivalence of output principle. Secondly, so it makes sense to offer access only to the third parties that will be able to comply with certain security and privacy standards to avoid security risk or privacy risks. So there should be some screening of access seekers too. And so we advocate for access licenses that would be granted based on objective criteria and possibly revoked in case of misconduct. The third set of recommendations aim to bring some economic analysis, I would say, in this debate. And so as economists, we are often concerned about the unintended consequences of regulatory interventions. And so in the report, we highlight two possibilities of unintended consequences. The first one is about this idea that interoperability, vertical interoperability within Article 6.7 must be provided free of charge. Though the precise scope of this principle is not entirely clear. So we think it's important to provide players, all parties, with the correct incentives, the correct signals, in particular in terms of investment and innovation. And we think that it requires that the cost of providing access for the gatekeepers should be covered, at least partly, by the access seeker. The second type of unintended consequences that we see concerns horizontal interoperability. And here we have the concern that horizontal interoperability could develop to the expense of multi-homing, that is, it could reduce multi-homing, whereas multi-homing of products and services in the digital markets is an important driver of contestability, another important driver of contestability. Therefore, we think that it's important after the implementation of the horizontal interoperability obligation to monitor the evolution of multi-homing for messaging services to check whether the development of interoperability does not come totally at the cost of reduced multi-homing, in which case maybe, well, the benefits would not be, would have to be compared to the cost in terms of reduced multi-homing. Okay, that's all. Thank you.
Thanks a lot. And I think what this specific example show, but also in other part of our report, we say here avoiding unintended consequences, but maybe some, given the way the text is drafted, will be inevitable, but then at least what we should try to do is to reduce as much as possible, because indeed, I mean, there is an obligation of horizontal interoperability in the text. And so the question is whether it reduces multi-homing. What do we do? And I think in a way, the Commission should apply the text, so should not say, okay, I don't apply it. But then the question is, what does it mean for the revision of the DMA? Because one thing is for sure is that there will be a revision in the DMA in the next Commission, because we know that the European law tends to be revised every 5 to 6 years. So every Commission has, and every commissioner has some things to do, but also that will be clearly an important thing to do in this case, because what is a bit implicit in the recommendation of Mark, but you correct me if I am wrong, is that maybe the horizontal interoperability as it is drafted was not the best things to do. And also for vertical interoperability, it cannot be completely free. No, the problem is that the text do not mention a lot of fees, so it's not easy, of course, for the Commission to deal with that. But you know, the thing is maybe to try to reduce as much as legally possible the unintended consequences, and possibly then revise the text as in 5 to 6 years, as we have learned from the first phase of implementation. Now, the second set of recommendation regard data. The first is regarding the data portability obligation that you have in Article 6.9 and 6 paragraph 9 and 6 paragraph 10 of the DMA. Now, here really the idea again is that maybe some more clarification on the scope would be needed and would be provided during the implementation, in particular, which exactly data are covered. No, by the way, this is the same discussion that we have in the GDPR. We have also a data portability obligation in the GDPR, and there is still an uncertainty on what exactly is covered by this portability, and we still do not have European case law on that matter. So, and the question also is whether we will do the same thing as that is in the GDPR or not. What context also should be ported or not. And then in terms of user consent, the question is how exactly this consent should be given, how granular it should be. Now, again, I mean, this is a series of questions that we have also in the GDPR, and the GDPR is in force since now 4 years or more than 4 years, and still there are some legal issues which are pending, and it's normal in a way, so that there is no, I mean, it's normal when you have a new law, you have new issue coming, and then it takes time to be clarified. So the point is, it's not a critique to the DMA at all, but it's just that this is the thing we think, or at least Jan Kramer thinks, that needs to be clarified. In terms of effective mechanism, there are in all the place of the DMA, we have a tension between, on the one hand, portability, or more generally contestability, and then other objectives which are very important and which are around privacy, security, and integrity. And you know, the DMA often mentioned that there is a trade-off between those things, but don't really solve that trade-off. And in a way, it makes sense. I mean, that trade-off will be solved in the implementation on a case by case. So again, it's not a critique of the DMA, but it's just a question that the gatekeeper will have to find the good way of, combining portability with those other considerations. One way also to help for that, to have effective mechanism in portability, is by using open standard and protocol. And of course, as for the this obligation, as for others, we will have to assess we will have to measure the availability of data and the performance of portability. But we have already mentioned when we were discussing effectiveness more broadly in the first panel. And then in terms of unintended consequences to which the enforcer, the Commission, should be careful, is that this portability obligation that you have in the DMA should not try to crowd out the personal information management system which are being developed, and which is also an objective of other policies of the European Union, in particular in the context of the Data Governance Act and the Data Act, which is currently being negotiated. So this is about the recommendation regarding Article 6.9 and 6.10. And then the last one is on data, the access to search data, which are in Article 6.11. So if we can move to the next and last slide. And that is, again, there will a number of clarification which would need to be given. So when we speak about search data, what exactly, again, what is the exact scope of data which is covered? What is the scale? What is the timeliness? And which are the beneficiaries? I mean, is it everyone, or is it alternative search engine which want to have those data? And there is also a geographical issue, which is a bit similar to what the one that Mark mentioned for interoperability. Probably this is limited to search data in the EU, but it's not totally clear to us whether that is the case. And in terms of effective mechanism, again, same trade-off between contestability and data access on the one hand, privacy and security on the other. And we think that to try to solve this trade-off in the most effective way, so to try to have as much as possible contestability and privacy and security, we would need to combine a mix of technical and institutional mechanisms. In terms of technical mechanism, I mean, there are some mechanisms which have been developed or which are being developed regarding key anonymity, differential privacy, and something which is more which is a bit newer, synthetic search log. So those are a way to share data without undermining privacy. And then in terms of institutional mechanism, you can have trusted data intermediaries. And again, this is also to be seen in the context of the Data Governance Act provision, and then some form of in situ data access, which alleviate that the data moved, and so therefore you have more security like that. And finally, here it's not free. I mean, the DMA is clear that there is a friend obligation, but then a friend requirement. But then the question, of course, is how you determine friend. And we know from the standard essential patent debate that it's a very, very complex issue. What we clearly would need, as it is the case for SCP, is a negotiation framework which leads to the determination of friend, and so maybe the negotiation framework which have been developed in the context of standard essential patent may be useful here. Okay, so those are, I think, the recommendation that Jan Kramer would have presented to you if he was here. And so now I will turn to our panelists to hear their view. So I will start with Matthew Ellison from Vodafone, then I will go to Francesco Versace from Spotify, and we will finish with Chiara Caccinelli from RCEP, but which has also an important role in BEREC. So I don't know if we can show Chiara on the screen, and then, but we will start with you, Matthew.
Many thanks, Alexandra. And thank you for the opportunity to participate in the conference today and for the publication of the reports, which are a really timely and important contribution into the regulatory discussion. I think for my remarks, I would like to focus more on the interoperability report. I think coming from a sector which obviously has regulations to deliver interoperability and reflecting also on the fact that, of course, these provisions appeared somewhat late in the day in terms of the DMA discussion. There is a lot of not only ambiguity within the regulation itself, but of course, detail which needs to be filled in when it comes to how to technically deliver on the provisions that you have under Article 7 of the DMA. So what do we like about the report? I think the first thing to note is that it usefully unpacks both the opportunities, but also the risks that could follow from kind of mandated interoperability for number independent interpersonal communication services. In particular, looking at the impact on multi-homing, which we absolutely do not want to dampen or disincentivize, but also on the features of those services that you're looking to interoperate. So the characteristics and of course the security, the encryption technologies that apply. And we think there is really a lot of merit in the recommendation of the report around having a sort of quasi-licensing regime for the access seekers. Primarily because this should really help to address and potentially offset the concerns which have been raised about the impact on, as I say, security and encryption of those services. In terms of an area that we could look in more depth or even improve upon the report, we're looking in particular at the reference offer, which will be sort of published by the gatekeeper in order to comply with Article 7. And we think the report could potentially go into more detail in the future as to what that reference offer would comprise, what information needs to be issued by the gatekeeper to those access seekers. And just a plug here, a commendation for the draft BEREC report on interoperability for number independent interpersonal communication services, where they include, and this is a draft report, so we still have an opportunity to comment, a sort of minimum set of information that would be included in that reference offer. We think that's certainly worth consideration and could potentially form part of an implementing act published by the Commission in the future. I would just underline within that process, the most important thing, and this is called out in the BEREC report, is that it has to be a dialogue between the access seeker and the gatekeeper. What would not be sufficient to deliver on the aims of the DMA is a sort of take it or leave it approach. Here is the reference offer from the gatekeeper. These are what you think, the steps we think you need to take in order to interoperate, and that's the end of the story. It really must be a dialogue, and ideally we would call out the role for standards bodies as well. So, speaking again from a sector where we have a global kind of interoperability standard in the form of GSM, this is not something we have today for over-the-top communications platforms and services, and there may be a role for European standards bodies in the future to help and assist with the implementation of Article 7. I think for the data access report, I will maybe save some comments for the Q&A, but because this was the more relevant for us. Thank you.
Thank you very much. And I think what you point is also something that Richard Fizzi pointed already at the beginning, is that the implementation of this DMA will lead to much more data sharing between the gatekeeper and the business user. And I think what you point here in terms of the reference offer and what should be in is one example of that. Thanks for this. So Francesco, what is your take?
Thank you. Thank you, Alexander, and thank you, Mark. And congratulations for delivering such a comprehensive report. I won't spend any time saying how much Spotify supports the DMA, because I guess most of you know that. So I will go straight to the point. I'll focus my comments on interoperability as well, and particularly on the vertical interoperability recommendations. I think the report does a very good job in detailing the complexity of the debate, at the same time recognizing clearly that both interoperability and side loading, especially in the long term, can be key to foster the goals that the DMA intends to achieve in terms of fairness and contestability. So that's definitely a big plus. And I take from the report that from a theoretical perspective, before the DMA has even been implemented, we can say that in perspective, the benefits seem to outweigh the costs. Another very important element is the regulatory backstop. which Mark, you mentioned in the presentation. For us, it's absolutely essential that despite the fact that the gatekeeper will have to have the first say in proposing the compliance mechanism, there should be a very strong complaint mechanism for business users and regulatory backstop on the side of the Commission. And this is valid both for the idea of how access is granted and potentially granting licenses. And secondly, to determine whether the potential privacy and security caveats and measures that gatekeepers bring to the fore are really justified and necessary, strictly necessary, as the DMA says, for the intended aim. We believe that that decision cannot be just left solely to the gatekeepers, so the role of the Commission here will be essential, and that's rightly reflected in the report. I conclude with one question mark, where I'm less convinced of the recommendation, which is on the condition for cost recovery of access. Understand the theoretical point. I wonder, however, from a legal perspective, how does that square with the principle, which is very clear in the obligation, that access should be provided free of charge? And also from a technical perspective, how this could be done in an effective way, avoiding that a gatekeeper could set could basically either exaggerate the cost or set the conditions in a way which eventually would create a competitive disadvantage vis-a-vis access seekers who compete with the gatekeepers on vertical markets. So these are my first reactions to the report.
Okay, I will give Mark the word to react to that, but maybe the answer would be you need an economist. But anyway, you know, Chiara, so you work at ARCEP, but also at BEREC, and you are very much involved on all those debates around interoperability. So your view is very much welcome.
Yes, thanks a lot. Thank you very much. So I will also focus mainly on the paper on interoperability. I hope you can hear me well.
Yes.
Yes, perfect. So what I liked is that the paper focused both on horizontal and the vertical interoperability, because of course in the DMA discussion before its adoption, horizontal interoperability for NICs took basically much of the attention, and which is also normal in a way, because it was provisions which were missing from the European Commission first draft and proposed afterwards by the European Parliament. So the discussion which was very much about this horizontal interoperability. But it's important to stress again how important the provisions for vertical interoperabilities in the DMA are. And they concern provisions which allow side loading of apps and app stores, and as well as access to essential hardware and software functionalities of the gatekeepers' operating system. So as it was explained before, and at ARCEP it was this is a key point. Already in 2018, we published a report on devices where we stressed that the freedom of choices of consumers with respect to content and services and applications that they could really choose on the internet was guaranteed, of course, at the network level with the Open Internet Regulation, but not at the device level. And we had identified some practices like pre-installation and incompatibilities of operating systems or by default settings as potentially problematic. So these new provisions in the DMA are really key and really a step in the right direction. So I decided to focus a bit more on the vertical interoperability, because I guess that I will have time to focus later on the horizontal interoperability as well, which is the main focus of telco regulators on the provisions of the DMA. And what I also really liked is all the references by Matthew to the report by BEREC. So thanks a lot for the promotion. Indeed, we have published a draft report on interoperability for NICs, and which is under public consultation until 3rd of February. So your comments are welcome. On one point, which is not really something that I didn't like, because I completely understand, but it's just maybe for future work. The point is that, I mean, let's say about the scope of the application of Article 7. because the legislative discussion mainly focused on messaging services, but the text of the DMA refers to NICs, which also involve other kind of interpersonal communication services, such as video conferencing services, for instance. So for now, the focus is on messaging services, which is, I mean, the legislative discussions were actually mainly taking place around this. And it's also the choice that we made at BEREC to focus on these services first. But it's probably, it will be interesting also to see how the markets evolve and whether these measures would be also applied to other services which are within the categories of NICs. And we also saw that some months ago, Zoom and Microsoft announced that Zoom Rooms and Microsoft Teams would be interoperable. So there are some interesting developments in the sector, and which may also teach us some more about like how to implement these horizontal interoperability measures and what are the strategies of the different actors. That's all from my side.
Thanks a lot, Chiara. So Mark, first your reaction. So you are lucky because everyone is talking about your report. So, so it's good that to have you here. And so if you can give your reaction of everything you have heard, and then I will take the question if there are. Again, I mean, if in the audience you have some question, please send it to the Q&A chat, and then we will address.
Okay, so I will maybe answer relatively quickly to the comments. So I thank you for all these comments about this report about interoperability. So I'm very flattered, and almost only positive comments. So I'm scared maybe what it can hide, but anyway, so I may have a question for Matthew actually. So I was hesitating to ask a question because I thought maybe it's a tricky question, but I said okay, let's go. And so I was wondering whether a company like Vodafone would be interested to ask access through the horizontal interoperability provision that is Article 7. So to make I don't know their own SMS services or advanced SMS services interoperable with, let's say, WhatsApp or things like that.
Thank you. I think it's certainly something to be explored. And again, another plug for the BEREC report. This is not pre-arranged with Chiara, but I'm pleased that you appreciated the reference. One of the things that it notices is the change in internet usage, kind of trends and habits, and how people communicate and message with one another has evolved over time. And I think if you see the drop-off in kind of SMS or MMS messaging has been a result of the lack of the ability to interoperate effectively with the if we can call them third-party kind of communications messaging platforms that you have on smart devices these days. So if we can help to support the objectives of the DMA, if we can inject more contestability and more choice crucially into the marketplace, I think that's certainly something that could be interesting to explore. The caveat that comes with that and the pitfall which I mentioned is there is a huge amount of work for engineers to be doing on these provisions. The kind of example of video conferencing, for example, is a very good one. There is not a standard today that exists that allows effective interoperability between video conferencing services, and much less anything more sophisticated than that. So I think that's the starting point. We need to make sure that our engineering teams are involved in this, and the reliance, as I said, on standards bodies to help move to a situation where you can benefit from the type of interoperability that we have today already for kind of traditional number-based services, where I have a number, you have a number, we can contact each other seamlessly anywhere across the globe.
And thank you. So and then I have maybe two comments, two answers to Francesco and then Chiara. So about the cost of the access price. So I understand that in the DMA it's written free of charge, and maybe so I play the blind guy, and then I think okay, maybe there can be still a price. But in any case, so what I see is that when a gatekeeper provides access to third parties, there is obviously a kind of opportunity cost. That is, they are going to lose business, and it's going to be already a cost. But on top of that, there could be direct costs related to buildings and interfaces. And as Matthew says, there is a lot of engineering that might be needed. And so if all these costs of engineering are not covered, then it gives very strong incentive to do the job really with minimum quality. Whereas if at least there is something like an idea that some of these costs might be covered reasonably and with some kind of regulatory oversight, then maybe you give incentive to the players, to the gatekeepers, to do the job relatively seriously and to bring enough resources to do that with good quality. So this is the idea also in the report. And then in Chiara's talk, so I was really interested by the example of Zoom and Teams willingly deciding to become interoperable. So the economics of interoperability shows that when players are of relatively equal sizes, they have strong incentives actually to become interoperable, even without any regulatory obligation. And there is a problem of incentive to become interoperable when there is a lot of asymmetry between the players, when you have a large player, again, a small one. And I think this is this type of asymmetric situation that the DMA wants to tackle. And so it makes sense. And so in this case, you have to mandate interoperability. And indeed, there are many things to assess, like the scope of the obligation, so whether it applies to more than what is written right now. So our feeling, so when we worked on horizontal interoperability, was the fact that you should not undermine innovation incentives. So a lot of these players in the marketplace, they create very fancy new features in their services, and you should not undermine these incentives. And therefore, also the interoperability requirements should apply to a reasonably small set of common functionalities to give enough room for differentiation and innovation to the incumbents.
Okay, thanks a lot for those comments. So I don't know if there is a question for the room from the room. Very short, because we have to. And then another one shortly. I will take the two short ones.
Yeah, just clarification. Sorry, I haven't read the paper yet, but I will do it. So maybe a clarification for Mark, because you said, of course, that interoperability would affect multi-homing, and that's for sure. But and you said also that could be a negative impact on competition. I don't see so much this point, because of course, I mean, multi-homing is a surrogate of competition. When you have interoperability, you internalize network externalities, of course. And I mean, I have not to explain to you, but so you don't have a barrier to entry for other companies. So how the reducing of multi-homing in a context of interoperability could possibly impact competition? It's not so clear to me.
Thanks. Hi, my name is Bert Haig from BBVA, Spanish bank. And it's about the free of charge data access versus the reasonable incentives you were talking about. And actually, given that it is put in the text that it should be for free, how do you intend to introduce those reasonable incentives until the next revision?
So frankly, I don't know. So it's really an economist opinion. So I forget about the text, and then I think, okay, well, it would be good to have a price. And so, of course, maybe legally it's not possible, but then for the next revision, I think it's an important point, at least that the direct cost of access are covered for the gatekeepers. And for Antonio's question, so the idea is the following. So interoperability here in the DMA, it is imperfect because it applies to a small set of functionalities. So there are common functionalities that are bound to be interoperable, and then there are non-common functionalities. And therefore, when you communicate with others through the interoperability interface, let's say, then your interactions are degraded. So you cannot use all functionalities from your services. Whereas when you multi-home, then you can enjoy the full set of functionalities from all messaging services. So multi-homing provides consumers with a higher quality of service than interoperability, because interoperability will always have to catch up with the set of functionalities, and then it should focus on a common part. So it cannot include all functionalities when they are not common between the players. And this is why when interoperability is going to reduce, if interoperability reduces multi-homing as we think it can, then you're going to orient the market towards something that is relatively powerful, but maybe with a lower quality of interaction. And we think it can enshrine actually the incumbency advantage of the gatekeepers. So, and then fail in this goal to have contestability.
Thank you very much to all the panelists. And now we go for the concluding session.
I will now invite Rita Wezenbeek to join us. Before I make my surprise announcement, we have Rita. We're very pleased to have you, Rita. Please come here. Be careful, there is a wire there. Don't trip. Rita is, as everybody knows, a director in this new directorate in DG Connect, which is in charge, which is going to be in charge of implementing the DMA, the DSA, and I understand that she's still, because she didn't have enough to do, she's still acting director for a former directorate, which is dealing with also very small issues such as fair share, but we cannot say that. So, voila. Rita, please, thank you very much to having joined us, to having stayed the whole meeting. So please share your views with us, where these things are going and what should we take from all this.
Thank you very much, Bruno and Alexander, for also inviting me and inviting me to do the closing comments. So indeed, I am in an existing directorate. It's not a new directorate, but we are reshuffling it. So indeed, very nice to speak with you. We're working very hard to implement this legislation right now. And I guess many of you are also working very hard to adjust to the new legislation. And in this context, I certainly personally highly appreciate the recommendations and the reports, which in a way place us 2 years ahead by already signaling what are the likely issues that are likely to occur. And there are indeed many very important issues signaled. It made me think a bit of another report that you've written, Alexander, where I saw the list is not exhaustive, but it is exhausting. And I think it made me smile also when I read that. And I think that is very much spot on. But I really appreciate this attempt also to help us in structuring the issues and indeed thinking already ahead. Well, this being said, it's of course also important to know that we do not have a crystal ball. We cannot predict all the challenges and obstacles that we will be facing in the implementation of this new legislation. And these challenges will, amongst others, will depend on the behavior of the potential gatekeepers, also of technological and market developments, especially regarding the contestability of markets. I mean, there may be suddenly new players on the market who do not even need the DMA. So all remains to be seen, and also the enforcement priority assessments. So this means that it is a bit of a situation like we always say, life is what happens to you when you're busy making other plans. But nevertheless, I think the report is very helpful. So I will not try to redo the discussion, and the disadvantage of having this slot is that at least everything has already been said 3 times. That also means I can be short. So I wanted to make a number of points around the 3 issues that we were discussing, basically designation, the compliance with the obligations, and also process and institutional design. So first, when it comes to the designation, one thing is clear, and that is the timeline. And it's also clear that this timeline is very ambitious. And this is why the early preparation is so important. And I understood Alberto has also highlighted this at the beginning. This is the reason why the teams have been inviting all the potential gatekeepers and also their competitors and consumer organizations to come and talk to us about how to best implement the DMA. And this is indeed very essential to ensure the effective compliance. So the designation process, of course, will be one of the key building blocks in deciding which companies are gatekeepers and also for which core platform services they are the gatekeepers. And this will require, and I understand Alberto has also said that, a case-by-case assessment, and it will require the determination of a user base for each specific core platform service. Now, in this context, of course, the question comes up whether within a given category of core platform services, there may be different services that are treated as single core platform services or multiple core platform services. In this context, the notion of purpose, as mentioned in the annex to the DMA, is very important. So also, indeed, I appreciated the discussion on this asymmetry of evidence. And indeed, there is a rebuttal possible with respect to the presumption of gatekeeper status. Now, it's indeed very important, as Alberto noted, and I think Michael repeated it. We need to build on the guidance provided by recital 23. And that means that I would also say that there's no symmetry between the evidence required for the rebuttal and evidence required for the identification of a gatekeeper. And that means that it's very relevant also that the link between the rebuttal and Article 3.8 has been cut. So that then means that we need to take into account, for instance, that there's no room explicitly for a justification on economic grounds, and also that the Commission can discard the rebuttal if it is manifestly ill-founded. And that leads me to another core issue which came back a number of times today, and I find it really important to underline that, the need for speed and effectiveness in applying this new legislation. It's not for nothing that we have it, and I think there's a strong determination also on the Commission's side to respect the intention of the legislator to apply this legislation effectively and speedily. So then the second building block, which is the self-executing, as we call it, and circumscribed, clearly defined and circumscribed obligations. So indeed, there is room for further specification where it is concerned, where the obligations are concerned. Also, the exact scope could be defined. And in this context, I mean, I also very much share what has been highlighted by a number of speakers, which is the key role of the compliance report. And there, I think, indeed, the role of the compliance report is at least twofold, which is on the one hand, it specifies also for all those who will be seeking access or will want to benefit in any way from the new opportunities created by the DMA, that they know how to go about. So that is very important for the outside world and for the effectiveness of the DMA. And it's also important for us as a regulator to see how we can enforce and how we can supervise. So I fully share the recommendation in the report that the compliance report needs to be clear and very easy to apply and easy to interpret. Now, that also brings me to another issue, and I think also that has been highlighted a number of times, but it's very important that implementation mechanisms by gatekeepers should be made in close cooperation with business users. So indeed, I would very much welcome, as suggested also by the recommendations, that gatekeepers seek to engage third parties, business users at an early stage to make sure that they get it right. And this is also part of the objective of the workshops that the Commission is organizing. So I very much appreciated and enjoyed the active participation of gatekeepers and others in the workshop on self-preferencing that we had. It was a very educational exercise, certainly for me, and I guess also for many others. And I think this works really well. And we plan to organize further of technical workshops of this nature, and to also inform the outside world relatively soon on what will be the topics and what will be the other logistical details. Now, I would also like to thank you for a very detailed analysis of all the individual points where further guidance could be needed. I will not go into all the details, but I find the call for guidance in a way legitimate and also understandable and fair enough. But I would also like to note that the legislation is just fresh. I mean, we had today one of the legislators in the room, and I would say now is not the moment for the Commission to, redo the work of the legislator by coming with new rules or new conditions or in the form of new guidance. So let's not start by adding criteria or conditions. So it's also very important, as has been observed a number of times, to first have a look at what are the real topics. And there we need the discussions also with the individual gatekeepers, and we need to look at the situations that we will be addressing. So also it's important, this is a new framework, new rules, and we need to also first have a look at what the rules say. Then also in terms of guidance, what I always like to think in a regulatory function, we speak through our decisions. So, I mean, the decisions are targeted to individual situations, and they are a first way of making clear what is our assessment of a specific issue. Now, anyway, it's also very important, both in the context of decisions and if there will be guidance, to first have the views of the gatekeepers and of the third parties affected. Well, we would not come out of the blue with our ideas without first having that input. And as Michael was saying rightly, I mean, there's always a reflection on should there be guidance on a specific issue. For now, we would think if there's any, then probably we would first reflect on giving guidance on process, as we have already done with the implementing regulation. Now this on the obligations, and then finally on the effective process and the institutional design. So I noted already that the compliance report is very important. I like the suggestion that this should be a living document, and normally they should be there every year. So there's an opportunity to make it a living and evolving document. So I think that is very good. Also very important in this context, in the evolving environment in which we live, is the importance of the regulatory dialogue, and also the possibility for the Commission to adopt specific decisions to address specific questions. Now, let me see, one issue that I found very interesting, and I can understand that also in the dynamics of this academic discussion, is the role for economic analysis. Mm-hmm. And I find economic analysis coming from the competition area is always very important. It's very informative. It is important to have a facts-based analysis, which comes often with the economic analysis. It can be good in terms of judging the effectiveness, proportionality, also whether there's de facto circumvention. So this is all very important. On the other hand, I very much agree with what Thomas was saying today. I mean, these rules are not there for nothing. So choices have been made by the legislator. And that means that for almost all, I would say all of the provisions that we have in the legislation, the choice has been made. So if you make a comparison with the regulation in telecoms, I mean, there have been decisions that there should be access. That means that there's no room anymore for an indispensability assessment. So choice has been made. And I think that applies to many of the provisions. Now then, certainly also, as I was already saying, the decisions to be adopted do not concern a process that is reserved only to the Commission and to gatekeepers. On the contrary, it is very much about what you could call participatory implementation and enforcement. So the views of third parties and stakeholders, consumers, will be essential during the whole process. Now that brings me a bit to the last point, notably on the broader institutional setup of the DMA. And that also concerns the involvement of the national competition authorities and the high-level group. As Alberto was already noting, the national competition authorities are reflecting on their own roles. They are considering legislation which would give them additional powers in the context of the DMA, which I think is very welcome, also because of their national expertise, their national knowledge of the markets. So they could play an important role. And then with respect to the high-level group, I think this is also a very welcome creation in terms of the high-level strategy and also the high-level expertise that we can benefit from. And we are currently finalizing all steps to formally establish this high-level group. And we hope to soon have the first constituent meeting with the high-level group. Now, before going into too many details, it's still good to signal indeed that we have just finalized the public consultation on the draft implementing regulation, where we have received around 30 replies. This is, I think, a very careful balancing act, which I like very much also from the viewpoint of getting it right under this new legislation, where we really need to find a balance between due process on the other hand, and then the recognition that this is new regulatory framework with, again, the need for effectiveness and speed. So I think we got it right in the proposal. I also understand from the colleagues who have already read the most of the replies that it seems that we are confirmed in this on the broad principles. There will, of course, be more details to be analyzed, but the main building blocks do not seem to be contested. So that is all very encouraging in where we are now. So let me not keep you too long because the drink is waiting. And again, high appreciation for the work done, high appreciation for the space to think that you take and that you give to all of us. So that is really good. And I really look forward to having our continued discussion.
Thank you. Thank you very much, Rita, for your encouraging words. And it's clear that we want to position CERRE as a public good. So something, in institutions which can be useful to policymakers, but also to our members. And our members are corporate regulators and academic centers. So basically, what I draw from the whole afternoon of discussion and what Rita says at the end is confirming me in my perception is that this is not finished. That there's still many uncertainties. In fact, the implementation of the DMA represents most likely the first case were gatekeepers and third parties will have interacted in order for the services to be delivered in compliance with regulatory obligations. And as such, there's not much experience of how to proceed. So this is why, and this is the surprise, this is why I'm very pleased to announce tonight that CERRE is launching the CERRE Forum on DMA compliance. This will be a trusted, neutral platform that organizes and facilitates dialogue among DMA concerned companies in order to contribute to an effective and proportionate enforcement of the new regulation. The forum will take the form of a series of seminars at which gatekeepers and business users who are likely to benefit from the DMA obligations, plus also when justified and upon ad hoc invitations, external stakeholders will discuss how to proceed. And at this stage, we would assign 4 main tasks to the CERRE Forum. First, focusing on measurement to agree and develop a set of quantitative compliance indicators. The second task would be to establish a compliance process. And there we think that this should include the identification of the various process requirements to implement the access obligations, how third parties' collective inputs will be developed, will be provided, how confidential information will be handled, and how costs and other resourcing requirements will be met. The third task would be to extend a bit what we've been doing in 2022 to Article 5.2 of the DMA, and to interpret and recommend how to implement the obligations provided for in Article 5.2. And fourth, to develop technical principles for compliance with the DMA obligations. And we ambition here to go one step further than what we have already been doing in the 2022 initiative that we have been discussing this afternoon. So we'll be providing our members with more details on this in the days to come. But we wanted to share this with those of you who are still with us at this stage. I see that there are close to 100 viewers online and you here. So if you wish to join this exciting projects, please don't hesitate to reach out to us. You can reach out to Konrad Ferenczi in the TMT team, and we will discuss this together. At this stage, I would like to thank everybody who has made this afternoon, I think, quite an interesting set of sessions. Of course, my colleagues, academics, the authors of CERRE, Martin Peitz, Jan Kremer, Marc Bourreau, Sally Broughton-Mikova, Amelia Fletcher, and of course, last but not least, Alexandre de Streel. I would like to thank the panelists. I won't list all of them, but thank you very much for having been here. I would like to thank the keynote speakers, Alberto, Schwab, and Rita. Still have some memory. And of course, I would like to thank very, very strongly my colleagues from the Secretariat, and in particular the TMT team, Tech Media Telecom, with Konrad, and the communications team with Simona Romeo and Ana Maria Schiadas, who have done really a great job. And also the colleagues from the audiovisual contractors. So now we have just next door some drinks and canapes, and we'd love to continue chatting lightly with all of you for this Verre de l'Amitié. Thank you very much.